Do you solemnly swear or affirm under penalty of law the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat. Lisa's going to get you a lapel microphone.
Richard Lewis.
Good afternoon.
Good afternoon, ma'am.
Detective Lewis, where do you work?
I am now retired.
And before you were retired, where did you work?
The Albuquerque Police Department.
How long were you with the Albuquerque Police Department?
Approximately 40 years. Retired the first time in 2004, and I retired again January 1st of this year.
And at the beginning of that 40-year career, did you receive some training to become a police officer?
Yes, all officers or officer candidates go through the Standard Police Academy. Then you go through on-the-job training with a training officer in patrol.
Did you, over the course of that time, receive specialized training?
Over my whole career, 40-year career, yes, I've received a lot of specialized training. What's pertinent to this case today was when I began working cold cases in 2006. I received a great deal of training in homicide investigations, interrogations, interviews, and a lot of training in DNA for investigations.
What's a cold case?
Cold case is, depending on what agency you're with, it could be an unsolved case that's a year old. It could be as soon as they're out of all investigative leads, it gets passed on to cold cases. Sometimes it's 3 weeks old and everyone's busy. So it depends. There's really no set of what a cold case is, but normally it's just an unsolved homicide. In our case, it was homicides, unsolved serial sex crimes, missing persons that were believed to be homicide victims, and unidentified remains that were believed to be homicide victims came to our cold case unit when I was there.
During your time as a law enforcement officer, did you yourself conduct some of the trainings that you kind of briefly told us about?
Yes, ma'am, I did.
What kind of trainings did you yourself?
So I did training of complex investigation, gang investigations, and then lastly, I did some training on just homicides and cold cases. I don't do a lot. I'm not a good public speaker, and I don't enjoy it, so I didn't do a lot of it.
Can you walk us through some of the assignments you had at the Albuquerque Police Department? You talked a little bit about cold case, but before that, tell us where you worked.
Every officer that comes on board starts in patrol. That's uniform patrol. You see in the police car the most visible officers you'll see. After about 10 years, I transferred into detectives. That was in about 1992. I went into our Metro Division, it was called back then, the Street Gang Unit, investigating gang crimes, including up to gang homicides. Then transferred to our Organized Crime Unit. Back then, that was the Major Narcotics Team. I then transferred to our Intelligence Unit. I retired in 2004 out of the Repeat Offender Team. When I was rehired in 2005, I went through another mini academy and back through OJT, or on-the-job training. And then from 2006 to approximately 2019, I was in the Violent Crimes Division, the Cold Case Unit. From 2019 till I retired in January, I was back in Special Investigations, the Criminal Intelligence Unit.
How many homicide cases do you think you reviewed or participated in working on?
Over the years, 300-400. I don't really count them. About that many.
And I think you already said this, but in 2017 you were with the Cold Case Unit?
I'm sorry?
In 2017 you were with the Cold Case Unit?
Yes, I was.
How and why in 2017 did you become involved with the Victoria Martens murder investigation?
I was first asked, I don't remember who the assistant district attorney was at that point, asked me to assist on trying to identify one phone number for some phone records, and then that was the initial assignment, was to identify a phone number that nobody could identify.
And tell us about that number. What did that turn out to be?
It turned out to be, it was difficult to determine what it was. It looked like it was a cell phone, but it turned out to be a number that belonged to the company that handles outgoing inmate calls for the New Mexico Corrections Department.
What was the date of that call? Why was it significant?
It was the date of the homicide, so it was August 23rd of 2016.
And once you determined it belonged to that company, tell us what you discovered.
I was able to contact the New Mexico Corrections Department. They tracked it down, and they were actually able to provide me the outgoing phone call that was associated with that. We saw in the phone records that the call lasted for just about 15 minutes, which was standard for outgoing phone calls at the time from the New Mexico Corrections Department.
Why is that?
They just cut you off about 15 minutes. Some jurisdictions it's 10, some it's 20. Just at that time it was 15 minutes with Corrections Department. They just shut you off.
And when you received that call, who was participating in that phone call?
It was a woman named Crystal Kelly, who was at the time incarcerated at the women's prison in Grants, made the outgoing phone call to Jessica Kelly, her sister.
Why was that call significant in your later investigation?
It occurred, I believe, around 6:09 p.m. on the day of the murder. So it was relatively close to what we thought the time of the murder might be. And so then we wanted to see what was being said. We believed from phone records that the phone call was made to Jessica Kelly, and at the time she was inside apartment 808, so we thought that was significant. When we reviewed that phone call, we became aware that it was very significant.
Detective, back in 2017, this case had a case agent, Sergeant Brown. So how did you become more involved after you found that first phone call from Crystal Kelly to Jessica Kelly?
After that, it's tough to explain. Sergeant Brown, time Detective Brown, was in the homicide unit. He was not relieved of all of his other duties. He was picking up homicide after homicide and happened to go out and assist on other homicides. I was first asked to look at some other phone records, and then I was asked to review the entire case to see what I saw.
Was there a point in time where you worked on this case full-time?
I began in late July, early August of 2017, and then around September, after Labor Day of 2017, until for almost a year and a half straight, I worked on nothing but this case.
Let me ask you this. When you first reviewed this case, was there an investigative theory in place?
It was more than a theory. There was 3 defendants had been charged. So 3 defendants were charged with a variety of crimes from first-degree murder down to tampering with evidence.
What did you know about this case when you came on board?
I was never involved in the case when it was initially investigated. I'd seen some stuff through the media, but really had nothing to do with it. I didn't know anything about it.
When you first began sort of your review of the case, did you rely on old information? Tell us about your process.
What I found I became very successful with when I was in cold case was I would look at everything I could get my hands on. Police reports, autopsy reports, phone records, interviews, transcripts, crime scene reports. I would do evidence views before I would go back and talk to the investigators. I found I was very successful in solving cases doing that way. Not that the investigators aren't very important, but I wanted to take a look at the case fresh before I heard about it and see what I saw on my own.
What's the danger of just talking to the lead detective and finding out what they think right away?
There's really no danger. It just, I don't want to taint. I can tell you I had one case of a serial offender that took us 20 years to finally get. He was sexually assaulting women all over the country. And after it was solved through DNA and he pled guilty and he's doing 400 years in federal prison, one of the original investigators from years before came up and told me, you got the wrong guy. So what can happen in these cases is the original investigators sometimes can get so wound up in their investigation that they can't see the whole picture. So I've kind of learned to look at it, and then after I look at it, I sat down with Josh Brown and others, and we talked about it for hours upon hours. What he saw, what he did, was incredibly helpful to have Josh there.
You mentioned a few things that you did in review of this case. Did you review the statements that existed from the defendants?
Yes, there was 2 defendants that gave what we call formal statements, or statements where they waived Miranda. That was the defendant in this case and Michelle Martens. Jessica Kelly did not provide a formal statement, but she made some statements during the investigation. And I would have reviewed all of that, both transcripts, police reports, and a lot of it was video and audio.
Did you visit the scene?
Many times, yes.
Did you review the lapel footage from the first responding officers?
Many, many, many times.
There's some photos and evidence where we can see parked cars. Did you run license plates?
What I found very helpful is our crime scene people, or that come out on our major crime scene, I'm sure the jury's heard, they're called criminalistics detectives. What they'll do is take overall photographs and they photograph every vehicle that's near the crime scene. So what I've done in the past, in this case, is you run those plates, you go back and find out who owned them or was associated with them back when the crime occurred, and you try and track those folks down to make sure that they were interviewed, and if not, that you interview them.
There were some devices, phones, collected in this case. Did you review cell phone data?
Yes, extensively. More than one time, yes.
Did you attempt to identify all the contacts in those devices?
Yes, that was quite a chore. We did our best to identify, I think, most of them.
Did you review, well, not review, did you make a jailhouse recording of Jessica Kelly?
Yes, I did.
Did you conduct evidence views of the crime line?
Several, yes.
And what is that? What did you do there?
What we do is we go back, we have the crime scene photographs and you can study those, but it really helps to go out and actually look at the piece of evidence at the crime scene. Some things we can open up and take a look at. Some things are biohazards, you have to look them through the clear bags. But a lot of times you can go through and, like a picture of a book is one thing, but to go back and go through every page in the book is another thing. So the evidence views that we did in this case were very helpful, I believe.
What type of experts did you consult with?
Oh, in this case was amazing. So DNA, first the state lab. We used an outside lab out of Florida. We had an arson expert. We had a crime scene expert. We used 2 different psychologists and a psychiatrist in this case. It was a lot of outside expertise was brought in to help.
Did you consult with multiple forensic pathologists as well?
Yes, we did.
How many, did you generate some reports?
Yes, I did.
How many reports did you write?
I wrote a total of 17 supplemental reports beginning in 2017. And then when I transferred out of cold case unit in 2019, I still continued to help where I could. So I think my last report was generated about this time last year, so last summer.
Did you work, we talked about experts and all the things you did. What about other agencies? What other agencies did you consult with on this case or work with?
Of course, New Mexico Corrections Department, Bernalillo County Metropolitan Detention Center, federal agencies including DEA and FBI. I had to travel on this, so we used outside law enforcement agencies to assist in North Dakota. I don't remember where else. We used an outside, the regional crime, or forensics crime lab. Of course, we used our crime lab, state crime lab. We also used,
Sheriff's Department?
I'm sorry, of course, the Sheriff's Department, yes, and state police.
Detective, let's talk about a misconception head-on. So you mentioned working with the FBI. Initially, there were some allegations of child sex abuse in this case. Do you recall that?
Yes, ma'am, I do.
Did the FBI assist with an investigation into that allegation?
Yes, they did.
And did they find any evidence of sexual abuse in this case?
They found no evidence supporting those allegations.
You yourself have talked about reviewing electronic records from different devices, and we've talked about phones, but were there other devices also collected during the course of this investigation that were forensically examined and then examined by yourself?
Yes, ma'am.
Was there any evidence of child sexual abuse on any of those devices?
I saw none.
During this investigation, the time that you were dedicated to this case, did you bring on some other AP officers to assist you?
Yes, over the year and a half, I was allowed to bring on a total of 3 for a short temporary assignment to work with me.
Why did you bring those detectives on?
Because the amount of work was massive. I was working 7 days a week. All of us on the team were working 7 days a week, sometimes not taking a day off for an entire month, and it got to be so much that I needed some help.
How many people do you think you've interviewed or had the assisting detectives interview related to this case?
Somewhere between 90 and 100.
Out of that number, how many ballpark, how many of those people turned out to have not much information or not very useful?
Most did not, that's normal.
We talked about you trying to identify the contacts in the phones. So would an example be that you'd reach out to someone and yes, they were a contact, but they just didn't have anything pertinent to give you or something like that?
There wasn't pertinent, or we had a lot of hesitancy.
Tell me about that.
As you can imagine, this is a horrible case, and there was a lot of people that, for whatever reasons, did not want to be associated with it. They did not want law enforcement coming into their house and talking about it, for various reasons. So it made it very difficult to find people. Some of the detectives I had come would spend weeks trying to find one person, and then you may not get anything out of it, the interview, I mean. So it seemed like nobody really wanted to be associated with this case.
In comparison to other cases that you've investigated, what's the scale of this case?
I can't even put a scale on it. I've never seen anything like this in my 40 years. I've never seen the Albuquerque Police Department allow one detective to, I had probably 25 to 30 homicides open in September of 2017. I closed them all down to work on this case. I've never seen the Albuquerque Police Department do that and then allowed me to take other people out of their assignments to work with me. They allowed Josh Brown to come back and work with us, even though he was swamped. I have never seen the amount of forensics examination ever. The DNA examination was amazing, but latent print, other forensics examination, other agencies stepped up to the plate. I've never seen anything like this in my life. I've never come close to writing 17 supplemental reports on any case.
Would you describe this case as confusing?
To this day.
Did your review and your investigation up to today align with the theory that was in place when you first came on the case?
Not totally. After identifying the phone number and retrieving that call from the corrections department and listening to that phone call, that's when I was asked to review all the reports. So I took about a week and a half. I was actually out of state on something where I could concentrate. So I started reading all the reports, all the transcripts, the crime scene report. I was watching the videos of the interviews with the defendant and Michelle Martens. And I started seeing something that I thought that there might be somebody else involved.
Now, we've heard a little bit about what was said in some of those police interviews. Based on your review of Michelle Martin's interview specifically, the day after her daughter's homicide, were the original detectives, in your opinion, reasonable in those initial charges that we've heard about?
Based on what Michelle Martens told us and what she said in those interviews, yes.
When you came into this investigation, what charges was this defendant facing?
First-degree murder, sexual assault of a minor, child abuse resulting in death, tampering with evidence, conspiracy, a great many. I believe there's somewhere around 20 charges.
As a result of your investigation, what charges remain today?
I don't want to say just my investigation. It was a group investigation, but the investigation from the Albuquerque Police Department determined that some of those charges just weren't appropriate. The defendant was not involved in some of those charges. And that was the point of our investigation is not to convict people, is to get to the truth and present the facts to the prosecutors. And then the prosecutors decide what the appropriate charges are. And that was my assignment, was to get to the truth.
Aside from general background information of the people you investigated, how far back in time from the homicide did your investigation go?
We normally take 1 to 2 years to see kind of what their lives were like.
Detective, we've talked a little bit about your 17 reports, and I see some binders there in case you need to refresh your memory, but how long would it take for us to go through every interview and everything that you did in this case?
We'd be here past Christmas.
Let's talk about some of the highlights of your investigation. You talked about going back a year or two in an investigation to see what people's lives were like. Let's talk about Michelle Martens and her children's lives before this homicide happened. What were you able to determine about Victoria's life before the defendant moved into her house?
Even though that Michelle Martens is a single mother, it seemed to be relatively stable. Michelle Martens had various jobs, Walgreens, Bye Bye Baby, and Smith's. She would keep a residence. Victoria was attending school. It seemed like a relatively normal young child's life.
What about the condition of her apartment?
The one apartment I had to look at and photographs, it looked like a loving mother. All over the walls were pictures of her 2 children, Victoria and Matthew. Other than the disarray from the incident, early morning hours of the 24th, it looked appropriate for a residence. There was food. It was relatively clean. Each child had their own bedroom. They had their own things. It looked like your normal household with two young children.
You said Victoria was attending school. Did you actually obtain her school records?
Yes, we did, from the Albuquerque Public Schools.
Any issues that stuck out about attendance or anything going on at school?
It looked relatively normal to me. There was some times she would miss school for illness and other things, doctor's appointments, things like that.
Nothing out of the ordinary?
Nothing that jumps out. She was about an average student, probably about like I was. She could have tried harder.
Let's talk a little bit about Michelle Martens. There's been lots of investigation in this case. You mentioned some psychiatrists and a psychologist. What was Michelle Martens like? What was your impression of her?
She's probably the most difficult person I've had to deal with in my career.
John, may we approach?
Come on up.
Want to softer chairs? There are two right there. You feel free to move into them. And if you want additional ones, you can roll them forward for those of you who are sitting in hard chairs, okay? So if you need to move to them, feel free to do so. You may continue. Thank you, Jim.
And that back on. So, you said she was difficult. Let me back you up a second. Did you speak to her yourself?
Yes, I did.
Now, tell us what you mean by difficult.
I had never really experienced anybody like Michelle Martens before. I guess the best way to explain it is I could talk her into this is a binder full of reports or a unicorn. I've heard the word suggestible. I have learned now from dealing with the forensic experts that talk to her, I know what the diagnosis is, but I'd never heard that before. She could be talked into anything or out of anything.
So when you talked to her, did you have difficulty sort of making sure what she said was real or true?
It was very difficult. It was one of the most difficult interviews I've ever done. I had to be very careful because I didn't want to. It almost seems like when you would ask a question, she took it as a statement and then she would expand upon it to please me. And that's what I saw in the original interviews also. And it was difficult for me. I've never dealt with anybody like that. It was incredibly difficult.
Just generally talking about her background, was there any evidence that she was engaged in drug use before she met the defendant?
None that I've seen, no.
Any evidence that she engaged in any abuse of her children?
No.
What were her finances like? You said she was a single mother with some jobs, but tell us a little bit more about that.
She's a single mother. She was working. She was getting her assistance, I believe, from her parents, the grandparents. But she had an apartment. She was clean. She was trying. She had a car. She was, all single parents, all parents in this day and age are struggling to get by.
In your investigation into her background, did you discover if she ever had people watch her children aside from her?
Just her parents, John and Pat.
You said John and Pat. Tell us who they are.
I'm sorry, John and Pat Martens. That's Michelle Martens' parents and Victoria Matthews' grandparents.
Did they support Michelle?
Yes, they were very supportive.
Did they help her out financially when needed?
Yes, they did.
Were they aware of the defendant or Jessica Kelly?
No, quite the contrary.
Tell us about that.
Objection calls for your statement.
Response? Your Honor, there's no statement that's being elicited. I'm asking what you learned about any efforts of her hiding the defendant from her parents.
Yes, ma'am. There were texts back and forth. There was one text, particularly on the day of the murder, when there was confusion of who was going to pick Victoria up at the bus stop, to where there was a text from Michelle Martens to a neighbor, and I apologize, I don't remember the neighbor's name, where was to go over and check and do things like that. So it was, and then the grandparents were, and I'm paraphrasing these texts, forgive me, the grandparents are like, are you going to pick Victoria up? And then back and forth, things like that. And it was clear from cell records and other records we found that Michelle Martens and the defendant were nowhere near the bus stop. So you could see there was some deception going on at that point.
We have just a moment here. You may. May we approach him? Come on in. Detective, during the course of your investigation, did you have an opportunity to interview not only Michelle Martens, but the other two defendants in this case?
Yes, I did.
And you also mentioned reviewing the initial police interviews with the defendant and Ms. Martens.
Yes, I did.
You told us about your impression of Michelle Martens. I think people pleaser was a phrase that you utilized. In your review of the defendant or Jessica Kelly's interviews, not a review of her interview, I'm sorry. In a review of the defendant's interview and your personal experience with Jessica Kelly and the defendant, did you have a similar impression of either of them?
No, I did not.
Let's talk generally about suspects in criminal cases being interviewed. In your experience, are they sometimes deceptive?
Yes, quite often.
Why are people deceptive when they talk to the police?
Not only suspects, but sometimes even our victims and witnesses. And that's what our job is, to figure out why people are being deceptive. The most obvious for a suspect is they're involved, but it could be they're worried about something else. They were out cheating on their wife. It was a drug deal that went wrong, but they weren't involved in the main crime. The same with witnesses and victims. I found that sometimes, they were cheating on a spouse, or they weren't supposed to be out doing something. So you see some deception there that you've got to weed out and get to the truth.
How common do you think that is?
It's not uncommon. Pretty much in every case I've ever investigated, there's going to be something like that you've got to figure out why this person's being deceptive to you.
We talked a little bit about Victoria and Michelle's home life. Let's talk about before the defendant, some background on the defendant, before he met Michelle Martens. Where was he living?
So my investigation showed in the months or so before that he had been living with his brother Joseph, and I believe he and a then girlfriend were living somewhere off San Pablo. And then I guess the best way to describe it is it was described as just couch surfing. The defendant would be looking for just a place to stay. He had no permanent address, no stable residence at that time.
During your investigation, I think you mentioned earlier that you looked a little bit into Michelle Martens' finances and that she had assistance?
Yes, she did.
What type of assistance was that?
The one I found was the state assistance. It's commonly called EBT, or electronic banking transfers, I believe. Essentially, it's a debit card that helps out folks that need a little bit of help. And it's like any other debit card. It has a PIN, and every month the state will put some money on it. I believe it's used only for food and things like that.
And she had one of those cards?
Yes, she did.
And you actually pulled the records from transactions related to her card?
Yes, we did.
Were there occasions between August 17th, 2016 and August 20th?
Objection?
Let's move to some specific dates around the time of the murder, specifically before the murder. August 17th of 2016, I believe was a Wednesday. Does that seem right to you?
Yes. Yes, it does.
Tell us about what your investigation showed, how the defendant, or where the defendant and Jessica Kelly met up with each other that day.
If I remember correctly, that was the day they were traveling around in the southeast area of Albuquerque. They went over to a repair shop, I believe it's called Pee Wee Autos, over off of Alcazar and Central. So they were generally in that area.
Do you know if that was the first time they had physically met up since Jessica Kelly's release from prison on the 15th?
She was released on the 15th. I believe there was some sort of contact on mobile devices before that, but I think the 17th was the first time that the defendant and Jessica Kelly had actually got together.
Were you able to determine if Michelle Martens and Victoria Martens sort of joined them at some point that day? At
some point, yes, both Victoria and Michelle Martens met up with them, both of them, the defendant and Jessica Kelly, I mean.
We've already heard some testimony from Jessica Kelly herself about driving around in Michelle Martens' car at the Downs Casino. Were you able to corroborate that?
One of the things I did in my investigation is we used a commercial database called Vigilant Solutions. That is, I don't know if everybody knows what a license plate reader is, but there's now both commercial and law enforcement cameras that will pick up your license plate and it goes into databases. The commercial ones are normally used by repo, and they tend to go to places where they're looking for these type of vehicles. So we had a hit on Michelle Martens' sedan at the Downs Casino that was picked up by a license plate reader as someone obviously drove through that parking lot.
And do you remember what time that was?
It was about 12:30 a.m. I'm not sure on the date right offhand, but it was middle of the night. It was really early morning hours.
Now you said that these, what I think I'm understanding from you on these license plate readers is this is someone driving around with this device?
What it is, and you'll see them sometimes, they tend to go where people, if you buy a vehicle, you don't pay, they have to find it. So they have people that have, looks like little cameras stuck on the side of their cars, and they will drive through apartment complexes, shopping malls, obviously the casinos, and when they get a hit, they can repo the vehicle. There's a system in their vehicle that tells them that vehicle's wanted to be repoed.
So oh, I'm sorry.
No, I was through.
So this hit, so to speak, on Michelle Martens' vehicle is just coincidental?
Coincidental. We get those, and that's the commercial side. That's not the law enforcement. It's a different database that law enforcement uses.
Did you get any other hits, so to speak, looking into those databases relevant to this investigation?
No. One of the things I did was you can ask the company and the computer system. I used a date and time around when the murder occurred and had a geographical location around the apartment complex on Irving. And unfortunately, the day of the murder, we had a lot of hits on the complex directly north. So it looks like nobody went into, whoever was out that day went into the complex to the north, if that makes sense. So we had a lot of hits in our geographical area, but it was not at the complex where the murder happened.
Was it the wrong complex next door?
Next door.
So no hits at all from inside the Arroyo Villas complex?
None.
Because they just didn't drive through?
Didn't drive through is my best guess.
That same night when you had the license plate reader hit, I guess for lack of a better way to express that, around 12:30, do you know about what time Victoria and her mom got home?
It was an hour to hour and a half. After that, it was early mornings, maybe 2:30.
Let's jump ahead to August 19th. That's a Friday. Tell us who Martine Martinez is.
Martine Martinez is a man that knew Jessica Kelly before she went to prison, and he met up with her through cell phone contact, and he met up with her on the 19th.
How did you first become aware of him as part of this investigation?
Reviewing the texts, there was some conversations in the text between the defendant and Jessica Kelly about a Martine. I was able to research the number associated with Martine's contact, and through law enforcement databases, I associated that number with Martine Martinez.
Was he also mentioned by the defendant?
Yes, originally in his interview on the 24th of August with the original investigators, he talked about a Martine that had been supplying methamphetamine to Jessica Kelly after she was released.
Where did Martine Martinez work in 2016?
There's a business called Freedom Auto. It's in the 11,000 block of East Central.
Were you able to determine if Martine Martinez was ever at Michelle Martin's apartment?
Yes, we were.
How did you do that?
Two ways. There was a full DNA profile detected from a pillow on the couch in the living room. And when I interviewed Mr. Martinez, he was initially hesitant and deceptive, but he finally admitted that he met up with Jessica Kelly at the apartment and that he had sex with her on that couch. And then when I obtained his DNA, it did match that full profile that we found on the couch.
And do you know what date he was at the apartment?
Friday the 19th, late into early Saturday the 20th of August of 2016.
Do you know, were you able to determine if Victoria and her little brother were home during that time?
I'm not sure about Matthew, but Victoria was home. I believe both were home, yes.
What type of vehicle did Martine Martinez drive?
He told me he drove his Harley Davidson. I think it's maroon, just a big Harley Davidson.
Did you question neighbors in this case? Michelle Martin's neighbors?
Yes, I've talked to the neighbors in this case.
Did you question any of them about potentially seeing Martine Martinez on his maroon Harley that night?
It was one of the things I always hoped it would stand out, and nobody remembered Harley being in the parking lot either the 19th or the 20th of August.
Was there any indication in your investigation that Martine Martinez came back to the apartment after August 20th?
No, on the contrary. We were able to obtain his cellular records, and after that, the cellular records confirmed his story that on the 19th, the Friday, into the 20th, that Saturday, that his cellular device was picked up there at the apartment in that area. And then after that, it stayed mostly on the east side of Albuquerque. And on the day of the murder, it was either near his business on East Central or his home, which is near East Central and Espejo.
Moving to August 20th, the actual day of August 20th, so now we're at that Saturday. We've already heard a voicemail left on Jessica Kelly's phone by the defendant, and a phone call, another jail phone call from Crystal Kelly from prison, where she contacted Jessica Kelly, and the defendant was present, I believe, in the car with her. In that voicemail that was left at 1:57, the defendant said he had something serious to tell Jessica Kelly.
Objection, leading.
Rephrase the question, or state the question again, finish the question and don't answer.
The question was going to be, he stated he had something serious to tell her. Where had he been just before that?
Is your objection still leading?
No, Your Honor, I'll withdraw.
Okay. You can answer.
Thank you, Your Honor. At the shop, it's Pee Wee's Auto Shop on Alcazar and Central.
And that was just before that voicemail was left?
Yes.
We then heard the incoming call, or the recorded call, I guess, from Crystal Kelly about 7:26 that same day that was played for the jury. What was significant to you about that call and the voicemail together, I guess?
It was significant that both the defendant and Jessica Kelly were together. She felt comfortable enough to put her phone on speakerphone. You could hear both the defendant and Jessica Kelly talking to Crystal Kelly at the same time. They were talking about a van being chopped, and I think very dangerous or crazy people being at Pee Wee's auto shop. It was clear that, to me, that the defendant and Jessica Kelly at that time were pretty tight. They were closely associating with each other.
Did Crystal Kelly have a nickname for the defendant?
I believe she's the one that liked to call him Faby Baby. I'd heard others, but I think that was hers.
Let's move to August 21st, 2016. This is a Sunday. This is the day the jury's going to hear testimony about a barbecue that happened at Amanda Padilla's residence. Your investigation into that barbecue was pretty extensive. Is that fair?
That's fair to say, yes.
Why was it so extensive?
During the barbecue, there was an incident to where the defendant was involved in a fist fight with Amanda Padilla and I believe Tasha Miller, former girlfriend. Shortly after that, he left the barbecue, and then there was a number of very direct threats that we saw on text messaging from the defendant back to Amanda Padilla.
You said that Tasha was an ex-girlfriend. Who is Amanda to the defendant? How are they associated?
I believe they're cousins.
And who is Angelo de Herrera?
Angelo de Herrera, I believe he has a child with Amanda Padilla. I don't know if they were married at the time. I don't know if they're married now. But that was his residence, I believe it was on Owen, where the barbecue was occurring on that Saturday.
Mayor Pro Tem, please. Did the defendant sustain an injury during that fight?
Yes, he did.
I'm going to show you what's been marked for identification. It states 357. Do you recognize this photo?
Yes, I do.
Does that accurately depict the defendant in the day after the homicide with that injury in the photo?
Yes, it does.
Your Honor, the state...
Your Honor?
Did you say objection?
Yeah.
Come on up.
been marked as 367, I'm sorry, 357 for identification. How did you become familiar with this photograph?
I initially observed this during my initial review back in August, September 2017. It's a crime scene photograph of the defendant taken that morning, August 24th, 2016.
Is this photograph, have you viewed other photographs of the defendant after the homicide, right around the time of the homicide?
Yes.
And is this photograph consistent with the other photographs that you've seen around the time of the homicide, as far as his injury?
Yes, it is.
And is this consistent with the other photographs taken by the crime scene specialist that morning?
Yes, it is.
Your Honor, the state would remove for admission of 357.
Same objection.
All right, 357, overruled, then 357 will be admitted, and you can go ahead and publish it if you want to.
Detective, were you able to determine if this injury is the one that was sustained during the barbecue?
Yes, it was.
Was someone named William Hollis at this barbecue?
Yes, he was.
Who's that?
Depending on who you talk to, he's half brother or quarter brother of Jessica Kelly. I believe they might have had the same father, but he's a relative of both the defendant and Jessica Kelly.
Does the defendant have brothers?
There's 3.
And at that barbecue on the 21st, did he make some threats involving his brothers?
Yes, the defendant did.
Whose car did the defendant leave the barbecue in?
Michelle Martens.
Was there mention of a black SUV?
In the text, yes, in the threats.
Were you able to determine if anyone related to this investigation owned a black SUV around this time?
Yes, we were.
Who was that?
Joseph Gonzales, the defendant's brother.
What time were you able to determine the defendant left the barbecue around?
Approximately 5 p.m. that Saturday afternoon.
I'm going to show you what's been marked for identification in states 367. Are you familiar with this chart?
Yes, I am.
And how are you familiar with it?
I've seen it before. I've seen this is just a compilation of some of the, I guess the text timelines, the events that happened on the day of the barbecue on August 21st,
And
2016.
have you reviewed this exhibit to make sure that it aligns with the phone records that you've reviewed and are also admitted in this case?
I have, yes.
Your Honor, the state would move for admission of states 367 into evidence.
Same objection.
367 will be admitted.
May I publish? Detective, after 5 p.m., or right around 5 p.m., when the defendant left this barbecue at Amanda Padilla and Angela Di Rivera's house, was there a spike in his phone activity?
Yes, quite obvious.
Can you walk us through some of the spike that you saw? And I'm publishing states 367. Does this exhibit kind of depict that spike in activity?
Yes, this is partial. I think there's 3 pages to this exhibit. On the left is the date, which is the day of the barbecue, August 21st, 2016, and then the next one is the time. That's the time, be the local time in Albuquerque. If there was no connection in approximate length, you'll just see it blank. The ones in the middle tell you how long the connection was made, who the call was made to, and the source from, and then the device, what was used.
So did the defendant have more than one device?
He had 2.
So he left around 5. I see some of these show a time and some are just blank. Are these blank ones where the call did not connect?
That's correct.
So I see Joseph Gonzales. Is that the same Joseph Gonzales you said is the defendant's brother?
Yes, it is.
And you verified this phone number?
Yes, I have.
And this is the William Hollis, Jessica's half-brother or potential brother, and his phone number?
His phone number at the time, he's changed it afterwards, but on that date, that was his phone number.
So I'm going to have you walk us through how many times did the defendant call his brother in the hour after he left the barbecue?
I believe the brother was approximately 19 times, and there was one call to Joseph Gonzales', it's either his wife or girlfriend, they have a child together, Sabrina. There was a call to her in that time period too. So a total of 20, I believe.
And that starts at 5:19 p.m.?
Yes.
So I see multiple calls at 5:19, a couple
Yes.
calls at 5:20, 5:21. Is that right?
22, 25, 43, 43 again, 44, 45, 45 again, 46, 47, 53. I'm sorry, these are all at 5 p.m. Again at 5:53, 5:56, then we move to 6:34.
And I see this as defendant at Brother Joe's. What does that mean?
At that time at 6:34, through phone and other records, we determined that the defendant was at his brother's residence.
And what time did you determine he was back at apartment 808, Michelle Martin's apartment?
At 6:46 p.m.
Detective, are you familiar with the Facebook records in this case?
Yes, I am.
Your Honor, may I approach?
You may.
I'm going to hand you what's been marked as dates 370 for identification. Do you recognize this document?
Yes, I do.
How was this document obtained by the police?
It's either by court order or search warrant. I don't remember which, but it was obtained through Facebook, their Facebook business records, and they were obtained through legal process.
And are these the records that pertain to the defendant's Facebook account around the time of the homicide?
Yes, they do.
Your Honor, the state would move for admission states 370.
No objection.
370 will be admitted.
May I publish?
You may.
So there was an exhibit admitted. Let me back up. Let's talk about Facebook business records for a minute. Tell me how those work and what issues you sometimes have with Facebook records.
There's, through my experience, there's two things you can get from Facebook when you request records. They're called business records or the native files. So when you look on somebody's Facebook page, they can have posts, their friends, different categories of things that Facebook captures. When you get business records, it's just this chronological list that goes from most recent to backwards, or to the past. So when you records, you have to read things backwards. If you get the native files, it'll have them separated just by the posts, and it makes it easier to determine when things were posted, when things were shared. So they can be very confusing. The business records can be confusing.
May I approach, Your Honor?
You may.
Detective, I'm going to show you what's been marked as 369 for identification. Do you know what that is?
Yes, I do.
What is that? Standard clock when you're looking at Facebook records.
So what I do is, I believe it's been talked about in this trial, is UTC time. UTC time is the time that we're apart. It's UTC 0 is Greenwich, England. And the further you go east or west, depending on what your UTC time. Business records normally come in UTC time, so we must convert those to either daylight savings time or standard time, depending on what time of year it is. I'm not real bright. I can't do it in my head like some people can. So essentially, I will, if something...
Well, hold on, don't publish it yet. Is this something that you use to help convert
Yes.
time? Your Honor, the state would move for admission of 369.
No objection.
369 will be admitted.
May we publish?
You may.
All right, go ahead and explain how you use this
Thank you.
printout of a clock with no hands.
So if I get a record that shows that something occurred at 3 a.m. UTC, and if it's during daylight savings time like it was here in August of 2016, I know I have to go back 6 hours because daylight saving time in Mountain is UTC minus 6. So I have to count back. Like I said, I'm not the brightest guy, so if it happened at 3, I'll go back 1, 2, 3, 4, 5, 6, which means it actually happened at 9 p.m. the day before, if that makes sense. There's converters, and now there's a lot of software that analysts have that you just plug stuff in and it converts it for you. Several years ago, it was down to the investigator and analyst sometimes to do things like this.
So that's your preferred method.
I make the least amount of mistakes when I do it this way.
Let me show you what's been admitted now. It states 370. This is page 2 of this record. I guess we'll go to page 1. So tell us what's on page 1. How does this identify the record, and how do we know it's the defendant's record?
At the top, you'll see it says Facebook Business Records. These are the records I've seen many times on this and other cases. This is how they come, the business records. The target number starts with 1000, 3 zeros, and then the rest. That is the number assigned to the defendant's Facebook account when he created it. And you'll see when it was generated, the date range we've asked for, the name that was associated with the account, the registered email, the registration IP address, current city, and then a phone number that's associated with this account.
So I'm going to show you page 2. And I see something here called a status update. Can you tell us what that is and what it's relating to? And Your Honor, actually, if I could ask the detective to come down and show the jury.
Sure, that's fine. We'll take a break in about 10 minutes.
So detective, walk us through how these work so we can all be on the same page.
So you can see here at the top is activity log. These records we requested, we have a total of 1, 2, 3, 4, 5, 6 activity logs. And you can see in this section, it shows there was on this date, the 24th, at 6:19 and 40 UTC, Fabian Gonzales' Facebook page shared a Faces Vargas Ramirez photo. And if you go down, you can see the records we requested, the time period. That's the activity log of what occurred on these records on the defendant's Facebook page. Does that make sense? So each one of these activity logs, status update, I don't know how many others are in this. Those are what I said, that's the native files that you can request where you just get that. This record, just chronologically backwards, just shows a chronological history of what was done. That's what comes in these records.
So tell us, starting with this status update, what this date and time is relating to.
So if I could refer to my notes, because I want to get this right, it can be confusing. So when you look, it's easier if I do it this way. So the first activity log event we see, this one here, is a photograph that was shared, and that was shared on August 24th of 2016 at 6:19 and 40 seconds UTC. So when you associate that with the actual, you have to go into the actual post, that associates with this photograph here. And the actual time that that was posted was August 24th, 2016 at 12:19 a.m. and 40 seconds. It would be Mountain Daylight Time, or UTC minus 6, on August 24th.
So this date and time here does not relate to this photo?
No, it's the one before it. That's why it gets very confusing. And that's why if you go with the activity log and you match that up that way, it's less confusing.
So walk us through the other posts or status updates and tell us the date and time that those were posted. converted from UTC then?
So the next post is the one that says, I smile and act like nothing is wrong. That would be the second activity log you see. Actually occurred August 24, 2016 at 12:03 and 31 seconds. That's UTC -6 or Mountain Daylight Time. The third post that we see says that respect shit goes both ways. When you convert it using the activity log, it actually occurred on August 21st, 2016 at 9:18 and 11 seconds, which is Mountain Daylight Time, and that's UTC -6. The last post in these requested records is, I'm just here to post funny shit on my page. Actually was posted, when you convert it, was posted on August 21st, 2016 at 8:23 and 45 seconds. And again, that's Mountain Daylight Time, that's converted, that's UTC -6. So that would have been Albuquerque time that this was posted.
So I'm going to show you what's been admitted as defendant's I, which I think is pretty identical except for it just came in from a different spot. Do the records duplicate themselves when you get them back?
Yes, sometimes they will.
So this is, I think, identical, except for the page number to the page 6 on states 370. Would you agree? Maybe a little different.
Bit different on,
The shares.
because this is the shares.
But let's make something clear. These dates down here on defendant's I do not relate to this photo. Is that right?
Because you have to read, it's chronological from, the records start from the most recent and go backwards. So it's kind of a backwards chronological, if that makes sense.
So defendant's I was actually posted on 8/21. At what time?
August 21st, 2016 at 8:23 and 45 seconds. And that is actual Albuquerque time.
Thank you, Detective. You can sit back down.
You want to take first one?
It's fine. Thank you.
All right, we'll take a 10-minute break. All right, jury.
Detective, going back to states 367, we were talking about this spike in activity. And so you just testified about some Facebook posts. So on 821 and 823, is that when the "if you get offended" post was placed on Facebook by the defendant?
Correct.
Which is in states 370, this last page.
Yes.
And then was there another Facebook posting that night?
The respect goes both ways.
This one?
Yes.
And what time was that?
At 9:18 and 11 seconds p.m. on the 21st.
Do we also see a call to the defendant's brother just before that?
At 9:02.
And was that a connected call?
Yes, for just about 5 minutes.
In the phone records, there's been some testimony that the defendant posted what's been admitted as 266, and I said posted them. There was a text message, and Deputy Commander Hartsock testified about this going out to Amanda Padilla. Are you familiar with that?
Yes, I am.
Are you familiar with this photo?
Yes, I am.
What time was this sent out?
That photo was sent out, text out at 10:02 p.m. on August 21st, 2016.
So that's a good 5 hours after the fight or so?
At least, yes.
In this photo, are you able to see any bleeding from the defendant?
And of course, the injury is covered up because of sunglasses, but he looks very clean. I see no blood on his upper body, his one hand and finger we can see, and on his face. I see no blood.
Do you know where this photo was taken?
That was taken inside 808, the apartment 808.
Were you able to determine what time Victoria Martens got back to the apartment on that day, the day of the barbecue?
She and Michelle Martens returned about 4 minutes later, after that photograph was texted out, I mean.
At 10:06?
10:06, yes.
And then tell us about the rest of the activity we see this evening.
As you can see, about 10:17 and 7 seconds, there was just under a shy a minute phone call the defendant made to Joseph Gonzales. 10:56, there is a call, 2 minutes 4 seconds, to Jessica Kelly. 11:05 and 27 seconds, there's 24-minute phone call, 24 minutes to where the defendant is using his mobile device and he's doing internet searches for firearms.
The next entry we see is for a phone call to someone named Robert Fine Sanchez.
Yes.
Did you investigate who that was?
Yes, I did.
Who is that?
Robert Fine Sanchez was one that was difficult to contact. He would only talk to me by phone, would not meet with me in person. The story he gave me was he was closer with the brothers, but he knew Fabian and didn't have any information about the murderers, what Mr. Sanchez told me.
Did he tell you the last time he had spoken to the defendant?
It had been a while. I don't remember the exact time, but it had been a while.
And he didn't actually end up speaking with the defendant, is that right?
That's what he told me. He did not speak with the defendant.
I'm going to go to page 3 of 367. We see a couple more attempts.
2 more attempts, no connections, 11:39 and 8 seconds, and then just a few seconds later, another attempt to Robert Sanchez.
The next entry I see is to someone named Sedmo or Anselmo Herrera. Who is that?
Anselmo Herrera, I was able to actually find an interview. He is a friend of both the defendant and the defendant's brothers. I believe he implied that he knew the brothers a little bit better, but he did know the defendant.
And did he know that the defendant had tried to contact him?
No, he did not.
And then after these attempts to contact Robert Fine and Sedmo, do we have some more communication?
Yes, 11:37 and 38 seconds, another attempt to Joseph Gonzales. 11:39 and 47 seconds, another attempt to Stephen Gonzales, who is the defendant's brother. And then at 12:55 p.m. on the 22nd, there was more internet searching for firearms. And then on the 22nd, about 4:37 and 38 seconds in the afternoon, the MAPS application is accessed. Then again on the 22nd at 4:47 and 13 seconds, And again, just a few seconds later, there was 2 attempts to reach Anselmo Herrera.
And let's just be clear, we go from the 21st at 11:40 to the 22nd the next morning, mid-morning at 11:35.
That's correct. We switched days, or we move into the next day.
May I have one moment, Aaron?
You may.
May we approach him?
You may.
we've talked a little bit about the defendant's phone activity after the barbecue. Let's talk about what happened at the location where the barbecue happened. Were you able to determine if anyone came over to the house after the defendant made a threat and left?
Yes, I was.
How did you investigate who came over?
Speaking with Amanda Padilla and her, I don't know if they're married, but the owner of the house, Angela de Herrera. Also interviewing Willie Hollis and Jessica Kelly. Had information about that.
Did you ever receive specific information about who might have gone over?
From Angelo de Herrera, he identified two men. One was named Carlos. He didn't know the last name. And one, I believe, was Elijah Griffin.
Did you try and investigate those guys and track them down?
Could never identify Carlos, but Elijah Griffin we did interview.
Were you able to determine if more than 2 people were there that came over after?
Based on statements, it appeared that way. Even Angelo de Herrera said there was more, but he just couldn't remember who showed up after these threats started.
Were you able to corroborate that Elijah Griffin, in fact, went over to the house?
Yes, he said he did.
During this part of the investigation, where you're looking for these people, was this one of those times in the investigation where people were less than forthcoming with you?
That is very fair to say.
During this part of your investigation, or during the course of your investigation generally, I should say, did you interview the defendant's 3 brothers?
Yes, I did.
Was someone else with you at each of those separate interviews?
Yes, there was.
Who was there?
Maurice Moya.
Who's Maurice Moya?
At the time, he was the investigator for Tom Clark, who was the defendant's attorney at the time.
Is he still the investigator for the defense in this case?
Yes, he is.
Why was he at your interviews with the defendant's brothers?
I went through him to arrange meeting with the brothers.
Were they willing to speak just to you alone?
No, they wanted me to go through Mr. Moya.
Was there anything about the interviews with Brother Joseph or Steve that was consistently inconsistent?
I got the feeling that this was 13, 14 months after the murder when I interviewed them. I got the feeling that they had been coached.
Why?
Specifically, we had some cell phone data location back at that time, so we had an idea where the defendant was on the evening of the murder. And they were off. And usually when I ask people, how do you remember a time a year later, it's because they were watching Jeopardy, or I always get off time at this, or there's something they associate it with. And specifically with Joseph, I asked him, are you sure? And do you think? And he's like, I'm not thinking, I know.
Now we've talked a little bit about, I'm going to steal your clock here, States 369, your UTC calculator, and how this can be confusing. Were the records at that time for the defendant's phone, were they non-converted UTC time type of records that you had to convert backwards and find out where you were? Do you remember?
I don't remember for sure. Most of the records in 2016 we were receiving would have been in UTC time, so there's a lot of having to convert. And then eventually we would convert them on our own, so we'd have them down to Mountain Daylight Time.
To your knowledge, did the defendant's brothers have any access to the phone records in this case?
To my knowledge, no.
Did Mr. Moya have access to those records?
He would have in discovery, yes.
Before your interview with the brothers, had he spoken to them before you?
Yes, I believe so. It's pretty obvious.
Did the defendant's brother tell you that something different than a fist fight happened at Amanda Padilla's house?
I believe Stephen told me that the defendant claimed he'd been pistol whipped, and Joseph Gonzales told me that the defendant said he'd been jumped at this barbecue on that Saturday.
When you interviewed Joseph, did he tell you about having contact with his brother after the barbecue?
Said yes, he had.
What kind of contact did he have?
I remember what stands out, he told me he had a call.
Did he tell you about 1, 2, 3, 4, 5 calls after the barbecue?
No, he told me a call.
Did he tell you about the 19 or 20 total calls that some connected and some didn't that his brother
He did
placed
not.
after the barbecue?
He did not.
In the Google location data, we see from 8/21, the defendant was at his brother's house. Are you aware if the brother was home, or do you know anything about that?
We don't have information that he was either home or not home, or they had any contact.
Did you interview Angelo Di Herrera directly?
Yes.
Did he actually personally speak? Well, let me back up. We've seen phone records on Amanda Padilla's phone, but did Di Herrera actually speak directly to the defendant this night after the barbecue?
He told me he did during the threats.
Whose phone was that on?
On Amanda Padilla's phone.
Was that a friendly conversation he had?
No, he told the defendant, who I think his words were, "Come on over."
In your experience with homicide cases, have you seen cases where people get killed over threats?
Yes.
Let's go back to William Hollis. We talked about him a little bit. How did he first become connected to this investigation?
The first thing I knew about him was his mother had reported him missing, and part of her report, she thought that he had been killed during this murder also. She couldn't reach him.
During your investigation, did you become aware of a birthday party held for the defendant's brother Steve on August 20th at Sandia Casino?
Yes, I did.
Was William Hollis at that party?
Yes, he was.
You said earlier you had to travel. Did you have to travel to talk to William Hollis?
On 2 occasions to North Dakota.
Why did you have to travel?
I had to go find him.
Was he hard to find?
Not hard to find, but he wasn't happy when I showed up.
Did he corroborate these people coming over to the house after the barbecue?
Yes, he did.
Was he present during the threats?
He knew of the threats.
After the barbecue, did you obtain his phone records?
Yes, I did.
After the barbecue, through the phone records, were you able to determine that William Hollis went that day?
So after the barbecue, he and Jessica Kelly began driving to different locations in Albuquerque. Eventually, later that evening, several hours later, ended up at Martine Martinez's residence on Espejo Northeast.
Did they meet up with someone referred to as the twins?
Yes, they did.
And around 2 or 3 in the morning, the next morning, where did Willie go per the phone records?
Willie Hollis left by himself, and then this weird driving around Albuquerque to North Albuquerque Acres, along I-25. This went on for several hours, and eventually eastbound on Interstate 40 into the mountains, in the East Mountains. He then drove, it appeared, aimlessly around the East Mountains for several hours. Eventually ended up parking in a very remote arroyo in the far southeast portion of Bernalillo County, and parked there for 23 hours. And then the following day, he drove into Moriarty and obtained a motel room at the Motel 6.
Were those movements unusual?
To say the least.
And Were you able to determine if he was in Moriarty or not at the time of the homicide?
We had, his phone records indicated his phone did not leave Moriarty on the day of the murder. And we have no indication his phone was ever at apartment 808.
We heard some testimony from someone named Uncle David, or David Chavez. Are you familiar with him?
I am.
Where does he live?
Lives in the South Valley on, I believe, Lake Southwest, I believe.
Did you interview him back in 2017?
Yes, I did.
Can you describe his property and residence to us?
It's a small residence with a kind of a dirt lot. I was never allowed in the house. He came out to meet with me, and there's a spot under a tree where there was a few chairs and kind of this dirt lot, and that's where I talked to him.
Did you notice anything about that area?
Yes, I did.
What did you notice?
Drug paraphernalia, used needles were just scattered everywhere.
And through your investigation, and specifically into the phone and location data records from Google, how many times did the defendant and Michelle Martens visit that address the day of the murder?
I'm not sure the exact number, but it was 4 to 5, I believe, during that day.
Does 3 sound right?
I'd have to refresh my memory, but 3 could be it, yes.
Were you able to determine the day of the homicide? We've heard testimony that the defendant took Victoria Martens to a gas station.
Yes.
Were you able to determine what time they were at that gas station?
It was right around 6 p.m. Without looking at records, I can't give you the time, but it was right around 6 p.m., just before or after.
We have a lantern.
You may. Is everyone good on your hats and hats? You may.
Detective, I'm going to show you what's been marked as States 368. Are you familiar with this?
I am.
How are you familiar with?
I've reviewed this to verify the dates and times.
And does this exhibit fairly and accurately represent things that you were able to establish during the course of your investigation?
Yes.
So you reviewed the defendant and Michelle Martens' Facebook records, T-Mobile records from the parties, the phone extractions, and the Google records?
And witness statements and CAD reports.
Your Honor, the state would move for admission what's been marked as 368.
No objection.
368 will be admitted in the solid.
since you've had the opportunity to review the defendant's cell phone data, Google location data, all of that stuff we've talked about, would you say that his movements on the day of the homicide, August 23rd of 2016, were typical for him?
Based on the records we reviewed for that time period around the murder, they seemed unusual to me, yes.
What seemed unusual about them?
He wasn't moving around much.
So let me publish what's been admitted as states 368. We've talked about this, whoops, too much. Sort of a compilation of some of the highlights. If you could walk us through some of these, or all of these actually, dates and times, and tell us why they're significant as
Yes,
far
ma'am.
as summarizing the movements the day of the homicide.
So these will all be on August 23rd, 2016, so I don't have to repeat the date, but of course that was Victoria's 10th birthday. At 12:33 a.m., the defendant sent a text message to Michelle Martens, "Hey babe, should you do a line with us?" 5:19 a.m., Jessica Kelly texted her mother Lori about quote unquote fucking up.
What does that mean?
Based on speaking with Jessica Kelly, that she was back on drugs and she was making bad mistakes.
Okay, continue, please.
Now we're into the mid-morning hours, about 10:33 a.m. The defendant, Michelle Martens, went to the South Valley where Upullet is. 11:41, defendant and Michelle Martens went to David Chavez's house. 12:10, the defendant, Michelle Martens, returned to apartment 808. 1:35, the defendant speaks with his brother Joseph on the phone. 1:53 p.m., defendant calls his brother. It does not appear that it was a connection. 2:02 p.m., again, brother Joe called the defendant, brother Joseph Gonzales, and that was in a connection for about 88 seconds. 2:25 p.m., the defendant called Michelle Martens. It's a 12-second encounter. 12:33 p.m., Michelle Martens texts Pauline to check on her apartment, on Michelle Martens' apartment. 2:36 p.m., Michelle Martens asks her mom, her mother, that's Michelle's mother, to get Victoria. 2:39 p.m., the defendant and Michelle Martin leave apartment 808. 3:08 to 4:40 p.m., the defendant and Michelle Martens were at David Chavez's, Uncle David's residence. 4 p.m., the school bus arrives at Arroyo Vio's apartments with Victoria. And we're still on the 23rd, 5:05 p.m. The defendant, Michelle Martens, arrived back at apartment 808. At 5:30, the defendant calls Michelle Martens, 6-second encounter. 5:31 p.m., Michelle Martens calls the defendant, 11 seconds. 6 to 6:25, this is when the defendant and Victoria drove to the Giant gas station. Victoria got a soda and the defendant got a bottle of vodka. 6:08 p.m. is the call I described earlier in my testimony from Crystal Kelly to Jessica Kelly. At 6:29, defendant and Michelle Martens go to Steve Gonzales' residence. 6:32, the defendant calls his brother Joseph Gonzales. 5 seconds, we don't know if there's a connection. 6:33 p.m., Joseph Gonzales calls the defendant. 3 seconds, again, I don't believe there's a connection. 6:34 p.m., defendant calls Joseph Gonzales. Again, it's only 3 seconds. 6:46 p.m., the defendant and Michelle Martens go to the Smiths near the apartment. 7:01 to 7:05 p.m., the defendant and Michelle return to apartment 808. 7:16 p.m., Nia calls Jessica Kelly. There's a conversation for 128 seconds. 7:22 p.m., the defendant calls his brother Joseph Gonzales. So there was a contact for 30 seconds. 7:34 p.m., the defendant and Michelle Martens are at Joseph Gonzales's residence. 8:01 to 8:24, the defendant and Michelle again returned to Uncle David or David Chavez's residence. At 8:48 p.m., the defendant and Michelle Martens returned to apartment 808. And this is all on the 23rd. At 9:04 p.m., Michelle Martens turns off YouTube. At 9:50 p.m., Lori Collins calls Jessica Kelly. Lori is Jessica's mother. At 10 to 10:35, Michelle Martens shows Facebook activity. From 10:04 to 10:28, the defendant shows Facebook activity. At 10:22 p.m., again, Lori Collins calls her daughter Jessica Kelly. 10:26 p.m., the defendant tells Alicia Aragon to, quote, "get over here now." At 11:05, now this is, I think it says AM, but I believe that's PM. 8:23, 11:05, I believe that's PM.
May I make a correction to the exhibit you're on, Steve?
I apologize, I didn't see that earlier. At 11:05 p.m., Michelle's phone is outside of apartment 808. 11:15 p.m., defendant's phone is off Wi-Fi and hits a cell tower. 11:59 p.m., just before midnight, defendant's phone is off Wi-Fi and is hitting a cell tower. Now we're into the 24th. At 12:03 to 12:10, Michelle Martens shows Facebook activity. 12:08 to 12:10, the defendant shows Facebook activity. At 4:07 a.m., Michelle Martens' GPS moves. And then at 4:34 a.m. was the 911 call from apartment 407.
Let's talk specifically about some of the times Victoria is seen. Were you able to determine the last time she's seen by neighbors?
The last time she's seen, for all the interviews and everything, is 8:48 p.m.
Is that when she's being carried downstairs?
Correct.
Ahead of that, when was the last time she was seen alive?
Last seen time is 7:05 p.m. on August 23rd, 2016.
Now, there's been some testimony about the defendant and Michelle bringing some cigarettes to Jessica. Were you able to determine if that is around the same time that Victoria was seen?
It's after they return from the grocery store and there's an argument over the brand of cigarettes or something like that.
And this 8:48 time, that's when we've established Jessica Kelly was carrying Victoria downstairs?
That's correct.
There's been some testimony that they were streaming music on YouTube, and I see an entry here that at 9:04 the YouTube is turned off. Is that consistent with the amount of time they might have been in that car?
That is correct.
Let's talk about the crime scene a little bit. What was most notable to you in your review of all the scene photographs and the lapel videos and the faro scan and all the things that you were able to look at in your review? What was the most notable thing about the inside of this apartment?
The thing that struck me after I reviewed everything was it seemed like there was two different scenes. And if I can explain,
Please.
from everything we've seen, we believed somewhere between 7:05 p.m. and 8:48 p.m. that Victoria's murdered. The defendant and Michelle Martens return around 8:48. From 8:48 till almost 4 in the morning, we don't really have anything. There's not neighbors calling us. There's no fighting. Things are going along pretty well. I'm sure you've heard testimony about the cleaning of the scene, how thorough it was, what was used, what was done. And then all of a sudden, around this 4:30 time, we get this 911 call. It seems to be a different scene, almost a panic. Some people will call it organized, and then it turned into a disorganized scene. So now you have Jessica Kelly in a panic, is now starting a fire, and she's essentially diving off the back porch. That didn't seem organized, didn't seem planned. That seemed a panic. So when I reviewed everything and looked at the scene, in the investigation, I saw two separate events, if you understand what I'm trying to say.
In your experience, or in your judgment, would there be any reason to clean that carpet and go through that cleanup if you were going to burn the building down?
No, that's what I explained. If the organized part was the cleanup and removing of items, and then all of a sudden it turns into, I'm going to burn the apartment down and dive off the back porch, that doesn't seem like part of the plan. It's part of the panic. Something happened. Something happened that caused Jessica Kelly to panic and make really bad decisions.
Have you personally been inside apartment 808?
Several times.
Did you ever test how the sound carries throughout that apartment?
Yes, I did.
How did you do that?
We did is in 2017, I believe, one of the visits is I took some of the detectives working with me. We went out and did our first visit, and instantly what struck me was how did they cram 3 bedrooms in this little teeny apartment? So I stood in the living room area, kind of in the center of it, and I'd have my partner go into a bedroom with both the door open and door closed and just talk. They had a conversation. Sometimes I couldn't hear exactly what they were saying, but I could hear the conversation. And I remember thinking, if I rented this apartment, I would be downstairs the next day saying, I'm moving out. There was no insulation, it seemed like to me.
We know that the defendant, we talked a little bit about the phone records showing the trip to the U-Pullet, and there was a part in Michelle's car that was broken. Were you able to determine if the defendant worked on that car outside in the parking lot at the Arroyo Villas?
Yes, after the U-Pullet, there was something to do with the whatever rolls up and down the window. The defendant was in the parking lot and worked on that, and I believe he replaced it with the part they got from U-Pullet.
When you spoke to neighbors, did any neighbors see this, as far as you know?
Not to me, and I didn't see anything in the interviews that indicated anybody noticed that.
Is this surprising to you that he might be outside and no one sees him?
No.
Why not?
It's a big parking lot. There's a lot of apartments. People come and go all the time. It's just not going to stand out.
Let's talk a little bit about some things from Jessica Kelly's phone extraction. Okay, approach on. Detective, I'm going to show you what's been marked. There we go. I'm going to show you what's been marked for identification as states 354, 355, and 356. Do you recognize these?
Yes, I do.
And are those, were those from Jessica Kelly's phone extraction?
Yes, they were. And
those are accurately reflecting what was extracted from her phone?
Yes, they do.
Your Honor, the statement moved for admission states 354, 55, and 56.
No objection.
354, 55, 56 will be admitted.
May I publish? Detective, I'm going to show you states 354. Can you tell us what we're seeing here?
That is Jessica Kelly on the right and the defendant on the left. That is the master bedroom in 808.
And 355?
Again, that's Jessica Kelly, and that is the bedside table in the master bedroom in 808.
356?
Again, that's Jessica Kelly in the master bedroom in 808.
And do you see a person back here? I can show you the actual.
It's difficult on that.
356. Approach like this. Do you see another person in that photograph?
Yes, I do.
Who is that?
The defendant.
Do you know when these photos were taken?
I don't remember the exact date. It was shortly after Jessica Kelly began associating with the defendant, and right around August 20th is when she began moving into apartment 808.
Are you familiar from your evidence views with some of the physical evidence in the case?
Yes.
I'm going to show you what's been admitted as States 26. Do you recognize, this is a scene photo, but do you recognize these items?
Yes, I do.
Looking at States 26 and States 354, do you see any items from States 26 that appear in the master bedroom with the defendant and Jessica Kelly?
It's a bit blurred, but you can see the sheets. I guess that's what you call them, the flower sheets, I guess they're called.
This purple bedding right here?
Yes.
Did you have an occasion to investigate some keys in this case?
Yes, 2 sets.
Tell me about the first set of keys you investigated, where those came from.
There was, I don't remember how many keys, but they had, I believe, a Smith's card and another, like a little a card you attach to your keychain, and it had a purple, like a wristband, a slinky wristband on it. That was found in the grass outside of apartment 08, the rear of apartment 808.
And that was collected by crime scene specialists at the time, or the crime scene detectives at the time?
Yes, during the original investigation.
Did you determine who those keys belonged to?
I did.
Who did they belong to?
A former resident by the name of Mary Lou Contreras.
So did they have any significance to the actual murder or any relation to the murder at all?
No, when I talked to her, she said she was out walking, lost her keys, and oh, that's where I lost them.
What about the other set of keys? Where did you...
There was another set of keys that I first noticed reviewing crime scene photos. There's a piece of like triangular furniture with several drawers in it in the master bedroom. And in one of the small drawers, there was a set of keys, a few keys, and again, it had like a fresh values card and other cards on it like that. That's the first time I saw those keys.
We're into the 300s in exhibits, so I'm relying on my good note takers to tell me what exhibit I'm looking for. I'm going to show you states 334. Is this? Not sure which way this goes, but is this the photo you're talking about? Is this the furniture?
Yes, that's the crime scene photo, and that is a small drawer in that triangular piece of furniture that was in the master bedroom.
I guess if we see this light switch, we can orient. This is up.
Yeah, the top of the triangle is up.
Okay. May I approach, Your Honor? You may. Let me hand you what's been marked states 363, 364, 365, and 366 for identification. Do you recognize those photos?
I do, yes.
Did you take those photos?
Yes, I did.
Where are those photos from?
Those are photographs from a set of keys that I obtained from Michelle Martin's father, John Martens.
And do those accurately represent the keys when you took those pictures?
Yes, they do.
Your Honor, the state would move for admission states 363 through 366.
No objection.
363 through 366 will be admitted and you may publish.
Thank you. So looking at 334, were you able to determine if the keys you received from John Martens were the same?
Is 334 the previous? I couldn't see the.
Yes, sorry, 334 is what's being published right now.
Yes.
So how did you know to get these keys from John Martens? Tell us a little bit about that.
I learned that after the scene was released, the crime scene investigators released the scene, Mr. Martens took those keys from 808 and held on to them until I went and retrieved them from him.
What did these keys, who did they belong to?
Michelle Martens.
How are you able to determine that?
One from John Martens, and two, the Fresh Value Rewards card you see there, went to Smith's and they checked and it came back to Michelle Martens.
We can see a car key here in 334. Do you see that same car key in 364?
I do?
Do you have reason to believe that belonged to Michelle Martens' Buick?
Yes.
And this crime scene photo, 334, this was taken the morning after the homicide?
Yes, it was.
During the initial search warrant?
During the initial search warrant, yes.
Let's talk about a little bit of other review you did in this case. Can I approach him? I'm going to show you what's been marked for identification. It states 358, 359, 360. Do you recognize these photos?
I do.
Where are these photos from?
Those were from the morning of the incident, so August 24th. They were taken by our crime scene investigators of the defendant inside the investigated crime van that was parked outside 808.
Was that Detective Pisano that took those photos?
Yes, it was.
And have you reviewed all of the photos he took in their entirety?
Yes, I have.
Your Honor, the state was moved for, and do those accurately reflect the photos he took that morning? I'm sorry.
Yes, they do.
I would move for admission, states 358, 359, and 360.
Same objection, Judge, lack of personal knowledge.
Can I see that, please?
Yes.
Overruled, 358 to 360 will be admitted and you may follow. Thank you.
Sorry. Did you have an opportunity, Detective, to compare the photos taken of the defendant the morning of the homicide inside the crime van taken by Detective Pisano to the photos of the defendant taken that evening after his interview taken by Allison Nodes?
Yes, I have.
I'm going to show you, I'm going to publish states 358. And Detective, if you want me to bring this to you, I know there's a glare, so you can describe it a little better. Actually, Your Honor, if I could have the detective come off the stand so you can point out.
That's fine.
Thank you, Your Honor. Detective, I know these get a little washed out when we put them up there, so I'm going to hand you 358's on the elbow, I'm going to hand you the other two. And if you could just walk the jury through what you see on these photos from that morning.
So on this photo, you can clearly see down here what appears to be dry blood. You can make out the faint outline of a clothes iron. And right here in this, I guess what I'll call the left little arm of the cross, you can see red stains right there that appear to be blood.
Is that also depicted in 359?
359 is a close-up of that. Again, you can see the dry blood, the outline, but you can clearly see the reddish stain in this area here.
And then 360?
360.
Tell us what part of the body we're looking at.
So this is the back right side. So this area of the defendant here. And you can see, again, the reddish stains that appear to be blood there.
And taking a look at what's previously been admitted as States 282, this is the photo taken by Allison Nodes after his interview. Do you see a difference in the defendant's back here?
Yes, as you can clearly see, all the blood is now disappeared.
Thank you, Detective. Did the defendant in this case admit to cleaning his fingernails?
Yes, he did.
Did he also claim that that injury to his eye that we see here in States 357 was a fresh injury?
Yes, he did.
And who did he tell that to?
The initial investigators the morning of the incident, the murder.
And you were able to determine that this came from the altercation at the barbecue?
Yes, that previous Saturday. I'm sorry, the previous Sunday.
The 21st?
Correct.
May I have a moment, Aaron? Thank you. Detective, you talked a little bit at the beginning of your testimony about experience, classes, and things you've taken regarding DNA.
Yes, ma'am.
Can you go a little bit more into that experience and training in DNA, and how often have you seen it in your casework in your 40 years
Yes, ma'am.
with APD?
So, when I became a detective in the cold case unit, I attended a course at the University of New Haven in Connecticut, the Henry Lee Institute of Forensic Science. And that was a cold case school that focused on solving cases through DNA. I've also attended, I believe, 2 more additional courses put on by the Department of Justice, United States Department of Justice, involving cold cases, solving them with DNA. I have been certified twice through the Albuquerque Police Crime Lab to collect DNA from people. I have investigated a number of homicides, and one of the things that we always focus on is the potential of DNA in our evidence. I've been able to solve a number of homicides through the use of DNA.
In this case specifically, was there already some DNA being analyzed when you first came on board, when you pulled that first call from Crystal Kelly?
I wasn't aware there was. All I was asked to do was pull that calls, but yes, I later learned there had been some DNA work done before I came on board.
When did you start reviewing all of the DNA results available in this case?
It would have been of September 2017, after I had begun reviewing and completed all the review of all the reports and witness statements, lapel video, things like that. I then started being made aware of some DNA reports.
So I think you were talking about you were on travel somewhere, and that's when you did that big push to review everything without distraction. right after that is when you started the review? Of
Yes,
the
it was
DNA?
after, I remember it was after Labor Day of 2017.
During your time after 2017 on this case and when you became a dedicated detective to this case, was more DNA requested?
Yes.
And did it go from one lab to DNA Labs International as well?
Yes, from the state lab to DNA International, that's correct, yes.
Why was the decision made to start testing at a secondary lab?
The state lab only has resources to test and with certain technology, where DNA International had, I don't know how to describe it, I guess better technology, more up to date, more advanced technology, so the decision was made to utilize that lab.
Did you yourself participate in times where you took evidence up to the state lab for testing?
Yes, many times.
And we've heard a little bit about male DNA in this case, and Ms. Archuleta from the state lab testified that there were about 33 or so buccal swabs aside from the standards that she had.
May we approach?
Sure, come on up. So we heard a little bit about, I believe the number was 33, I might have that number wrong, about all of these buccal swabs or standards, the Q-tip that went into someone's mouth, that got delivered up to Ms. Archuleta in the state lab. Do you know where those came from?
I do.
Where did they come from?
I collected them.
During your investigation, when the DNA started coming back and there was a Y profile on Victoria's back that was comparable, why was it important to you to figure out or try to figure out who that might belong to?
That very well could lead to who's involved in this. It could be, we were concerned it could be a first responder or somebody who may have visited the scene. So I met with the officers, first responders, I believe even an ADA that went to the scene and collected their DNA standards.
So every male that you're aware of that was at the scene of the homicide, you collected a standard from and it was tested by Ms. Archuleta?
Except for the defendant, I did not collect his.
Who else did you collect standards from?
From logical people that may be suspects or that we wanted to rule out or rule in based on that partial Y profile that was detected on Victoria's back.
So we've talked a little bit about Martin Martinez and William Hollis. Did you collect their standards?
I did, yes.
Who else's standards did you collect, if you can remember?
Oh, Angelo Di Herrera, Elijah Griffin. I'd have to go through my reports, but everyone who would be, I don't want to say a person of interest, everyone that we needed to exclude or potentially include in this investigation, whether it was, like I said, a first responder or somebody who possibly could be involved that we identified that we could find. I tried to collect their DNA profile, or DNA standard, I apologize.
Why just males?
The only profile that we could do any comparison was the male, what's been called the Y, partial Y profile, or the male profile, that was detected on Victoria's back.
When you first reviewed the DNA, sort of that initial DNA, was it what you were expecting was going to come back in the DNA results?
No, it was not.
Did it lead you to believe that there was possibly someone else involved?
I had already come to that conclusion that it was a possibility, and then once, after I came to that conclusion, I was supplied the initial DNA reports, and that's when I learned of the partial Y profile that the defendant had been excluded from. It was detected on Victoria's back.
What were you expecting there to be?
Well, of course, you'd expect the victims, Victoria's, to be on there. Her mother. In a way, I even expected the defendants to be on there. Jessica Kelly. That was the people she was around in the hours before she was murdered.
Let's talk specifically about the places on Victoria's body where DNA was found. We have states, to get the easel here. And Your Honor, if I could have Detective Lewis step down again. Sure. We have states 314, which is just a body outline, and we have Michael Jarvis from OMI just sort of walk us through where on Victoria's body swabs were taken, where they actually swabbed. So on the front of Victoria, can you tell me where the places were on her body that were significant to you in your review?
To me, since I learned she died of manual strangulation, and in my experience in training, when you have manual strangulation with a victim, they're going to fight. And it's work. So with that struggle, you get friction and you get what's called touch DNA. The cells come off. So I was very concerned there around Victoria's neck. Next, in my experience of working other strangulation homicides, are the hands and the fingernails. Because when you're being strangled, you're going to fight. And based on what I've seen the entirety of the investigation, Victoria fought like a hero for her life. So those were the main locations I was looking at. That's what I've looked at before in strangulation cases. Those were the locations I would expect to see who was involved in a manual strangulation.
So we know from the testimony of the DNA analyst that in all of these locations, while there may have been Y DNA located, it was insufficient or like such low level they couldn't even tell us anything about it.
Objection, leading.
Rephrase the question, sustain.
If Victoria's body was cleaned or wiped down, would that impact your understanding of the DNA found on her body?
Yes, it would.
How so?
Any type of tampering with your scene, whether it's a body or a crime scene, any type of tampering, washing, cleaning, putting water on it, adding something to the scene has the potential of either destroying or diminishing the evidence, in this case DNA, that we find.
We've heard a little bit about the possibility of transfer, and there was some testimony or a question, I believe, from the defense about her being a rough and tumble kid. Tell us what you think about the possibility that all of this Y DNA on her is just transfer.
That's something we looked at.
I'm sorry?
If we could approach it, yeah.
Come on. Detective, there was some talk about Victoria being a rough and tumble kid. Did you obtain her school records?
I did.
And was there any indication in those records that she had been in any altercation or fight or situation that day?
On August 23rd, 2016? No, none.
Was the school pretty thorough about documenting incidents and headaches and stomach aches and scratches?
Yes, they had like a nurse's visit medical log. They went back to 2014. There was illnesses and hurting because she was on the monkey bars, things like that. They were pretty good about documenting any type of incident.
Going back to your experience, how many strangulation cases, or have you worked other strangulation cases?
I have, yes.
And tell us about what you expect to see in a strangulation case DNA-wise.
Where the injury is, this case, the manual strangulation, I would expect, unless someone's wearing gloves, I would expect to see transfer. And I know from previous interviews of offenders who have talked to me after they have strangled somebody to death, very consistently they talk about how difficult it is. They talk about their hands being tired. One defendant who confessed to trying to strangle a victim to death, she couldn't finish, and they had to kill that victim another way because of the victim resisting. In all of them, the victims resist if they're conscious until they become unconscious. And that's why you expect to see the location where the strangulation happens, this case in the neck, around the neck, and you expect to see it on what they're going to fight with. Their hands, specifically their hands and their fingernails.
Are you familiar with what Victoria wore to school that day?
Yes.
Can you describe that article of clothing for us?
It's been described as a one-piece jumper. It's a single-piece outfit.
May I approach her?
You may.
Detective, I'm going to show you what's been marked as States 362, and I will just let the court know this is a graphic photo.
Let's go ahead and remove the camera, please, from the...
Are you familiar with this? Oh, I'm sorry.
All right, thank you.
Are you familiar with this photo?
Yes, I am.
Where is that photo from?
That photo is from, it's of Victoria's neck and was taken still at the crime scene before she was transported to the Office of Medical Investigator.
Is this a photo that the Office of the Medical Examiner's investigator took, as far as you know?
I believe so. All I can see is gloves. It could be our crime scene people. It could be OMI personnel. Usually OMI personnel handle the body.
And have you thoroughly reviewed all of the photos from the scene and from OMI, including their on-scene photos?
Yes, I have.
And does this accurately reflect what you've seen in those photos?
It does.
And the condition that you know Victoria Martens to have been in after review of her autopsy?
It does.
Your Honor, the state would move into evidence what's been marked for identification as 362.
No objection.
362 will be admitted and you may publish.
Thank you. Detective, let's look at 362. Tell us what we're seeing here.
That is a photograph of Victoria's neck the morning that she was located, August 24, 2016.
What are we seeing here?
Extensive bruising on her neck.
Is that typical for a manual strangulation homicide?
In my experience, yes.
And why is this location and the bruising here significant to you in your review of where DNA might be?
As I described before, when you have manual strangulation, you have usually a struggle, you have friction, hands on neck, and then you could have transfer of what we call skin cells onto the body. And I would expect, if there was not gloves worn, there would be a possibility we could recover DNA of the offender at that location.
We talked a little bit about the kids, or there's been some talk, I'm sorry, about kids at school, and you said you went through her records, having not seen an incident that day. Is that why you did not go collect swabs from all of the kids in her class?
Not just based on APS records, we had nobody tell us that either at school or outside of school that Victoria had any type of rough and tumble, wrestling match, physical contact with either kids at school or kids in the parking lot.
Would you expect transferred DNA on someone's neck just from going to school?
I would not know.
What about there was some testimony about some teenage age kids that were outside around 8:48 that saw her being carried downstairs. Did you consider getting swabs from them to test against the profile on her back?
2 were females, so no, and 1, we had no information that she ever got close to Victoria.
Do you have any information that any of them got close to her?
No, not at all.
Was there any information that she played with any other kids in the apartment complex that day?
That day, no.
I think you can take this stand in. Was it significant to you that the DNA found on Victoria, her neck, hands, and fingernails was a Y DNA?
Yes.
Blood DNA?
Yes.
Why?
That would tend to lead me to believe as an investigator that a male was involved in Victoria's death.
Do you have a moment, Aaron?
You may be seated, and you may step down.
Thank you.
Seated on the way.
Thank you.
Judge, I also have another exhibit that we should probably talk about now that'll be coming in through Detective Lewis. But I'm sure, well, unless the defense has no objection, but I would imagine they may.
Okay. So you want to start with the exhibit and then we'll get to the jury instructions?
Sure. So, Your Honor, the state has tendered, what number? 371 for identification. I'll hand Your Honor the actual exhibit. It's the plea and disposition agreement for Ms. Martens. It's been redacted to remove the degree of crime and the penalty. And the name of the crime.
Mr. Ernest?
Well, this seems to track the court's order, so.
No objection?
You have a moment, Your Honor.
Concern would still be with this.
What's your concern?
The original concern which was that the jury would basically figure out.
Okay. You getting him okay?
I can be loud, I can use this.
That's what I
The concern would be that the jury would compare what she's pled to with what he's facing and figure out she's basically pled to it. That's the concern. And having the years in there, it's a substantial amount of time. I mean, obviously she is incarcerated and she has pled to something. But I think introducing the plea and disposition agreement moves us a lot closer to the jury going, wow, she pled to it, he didn't. He's at least as involved as her, or more so.
How is this different than Jessica Kelly's plea? The only thing I see different, the only thing that's concerning to me is under sentencing agreement, we're talking about mitigating circumstances. But as far as Jessica Kelly's plea agreement, which, let's see if I can find that exhibit. And there was one of the defendants, I'm pretty sure.
Right. I can speak to that if you're ready.
Yeah, let me find her. That exhibit.
I do think the court's correct that it's similar.
It's defendant's aid.
And I think that's what Mr. Ahrens was referring to, but I don't think they're similarly situated in any such way. The reason that we were able to get into the plea agreement as the defendants with Jessica Kelly was because Jessica Kelly was testifying against our client, had turned state's evidence, and the defendant is generally allowed a great deal of latitude to attack that person. And part of that attack involves the plea and disposition agreement. Here, the concern with the plea and disposition agreement and the concern with focusing on what she has pled to is that the jury may go me too. And there is case law on this. I think we argued it, but I cannot remember it. But I know I looked it up. There's case law that says that's really not okay to say this person pled to the same charge. And then,
But there is no, the charge isn't on there. That's what I'm a little confused
I
about.
understand the charge isn't on there, but I'm saying jurors are very smart, Judge, and they look at that sentence, 12 to 15 years, and they're going to guess pretty quickly it's going to be the same as the other as the other guy is being charged with. I think they're going to figure it out just like that. So I'm concerned with that. I don't mind.
Just so I'm clear about what you're arguing, are you saying the jury is going to be concerned with the consequences of their verdict based on the consequences that Ms. Martens faced?
No, that's not what I'm saying. I'm glad you're asking me that, Judge. No, the concern is that when one person has already pled guilty to a charge that another person is facing, the jury compares the two. And if they compare the two, that's really not the right basis to decide this defendant.
And I agree with you 100%, Mr. Dingler. That's what I was trying to clarify, because we don't know what Ms. Martens pled to, and we don't know what she was facing, and the jury won't know that. Right? And so we don't know. I mean, I understand that there's that sort of risk that if one person, which is what I think you're getting at, if one person has pled guilty and they were all sort of acting in concert, then the other person must be guilty too. And so you're concerned that because I mean, it's not a secret she's pled. We know she pled. That's already come out.
It is not a secret.
So,
and it's also not a secret that she's been in jail for 6 years, because I understand she'll be in shackles and all
right.
the same as the
so
other.
her credibility is still an issue too, which is why, and any bias she might have is also an issue, whether she's a defense witness or a state witness. Any bias or interest she has in the case and her own, outcome on her own case is all at issue. Doesn't really matter who's putting her on as a witness. So I would agree with you if we knew what Ms. Martens was charged with and we knew what she pled to, and then you could say, well, that can transfer over to the defendant and he could be held to the same, he'll be held accountable too, because that was his girlfriend at the time and they were all sort of acting in concert allegedly. But clarify unless I'm missing something.
Okay, I'm with you all the way through it, excepting for the number of years. In Jessica's case, the question was, did she get a deal? And so we could argue the years and say she got much less time. And I think she said she was facing 200 years, so it was all, the years came in. In this case, I think the years are troubling just like the charge is troubling, because there's so much time involved here. The jury's going to think, wow, she pled to this. That's what I think the jury's going to think, and I think the years are going to be the signal to them, even though they don't see the charge, even though parts of this have been blocked out. I just think that this is a dangerous document.
So be more specific. The years are going to signal to them what?
That she was convicted of the same crime he's being charged with. The same crime thing that I'm concerned about.
Because of the years.
Because I think jurors are smart.
Steve?
Judge, I don't think there's a danger. I think we've redacted it, and if the court has a concern about the mitigating circumstances line, we're happy to redact that also. I think that this is relevant to this detective's testimony, especially when the implication has been made or almost outright said that that there's sort of just this railroading of defendants, and Jessica Kelly got this super sweet deal. I think the balance of that is showing this plea document, which is properly redacted for the court's, I believe, January 6th order, which I was trying to pull up, but it wasn't fast enough. So I think that this goes not only to, in the interest of balance, to show, what they've tried to do is show that Jessica Kelly had all these charges dismissed. I think it's equally relevant for this detective to talk about all the charges dismissed against Michelle Martens as well in the balance of his investigation. Also, they're calling her statement a false confession, indicating that it's all false and that she was totally innocent is the implication. But in fact, the conclusion was not that everything she said was false, basically only the things around the human trafficking and sexual assault, that's kind of where it went off the rails. But she did say a number of things on the front end that were not deemed to be inaccurate. So I think that this push that she falsely confessed, everything she said was completely false, and that, I think all of that together makes this admissible and relevant to show not only how this detective conducted his course of investigation and how things kind of got dropped as he went through and determined this isn't right, and how we sort of leveled that down, and also to rebut them claiming it's a false confession when she pled.
And if the concern is from the defense, the number of years, I mean, when she gets up to testify, are you saying that the state's not allowed, or the defense is not intending to explore the number of years? I mean, because what I'm getting from you, Mr. Dangler, is you're concerned about the years. Everything else is fine, but the actual years that she's serving is where your concern lies within this plea. Is that right?
Yes.
And so are you saying that you're not going to explore the number of years she's serving, and that the state is not allowed to talk about that either?
I was going to talk to her about how she's been in jail, and she's made a plea agreement with the state, but I wasn't going to go into how many years she's facing.
And are you arguing that the state should not be allowed to ask that?
What I'm worried about with this document is the undue emphasis it may place on those years. I realize there's got to be some latitude, but
So then the answer is no. You're not objecting to the state asking the number of years.
I think that the state can get into things, but because it's here on the face of the document, I think it puts undue emphasis on the time, and I think jurors are really smart and they'll figure it out.
I still don't understand what you mean by figure it out, but let me look at my order from January.
I believe it was January 6th.
It was. So I'm looking at my order from January 6th, and it's specific to Kelly and Martin's plea agreement. And it says in paragraph 2, the court finds that in direct and cross-examination of co-defendants Jessica Kelly and Michelle Martens, either party may fully inquire into the parameters of their respective plea agreements as it is relevant to bias, including the agreement to give a truthful statement, a comparison of the overall time the witness would have faced, and the time they are facing under the agreement. Sex abuse charges will not be used in the calculations because they were not dismissed pursuant to the plea agreement. The name of the charge, it says charges pleaded. Yeah, charges pleaded are not allowed, nor the amount of time involved in each particular charge. So, this seems to comport with my January 6th order that it's fair game. The only thing that I'm seeing an issue with, because again, if the name of the charges were in here and the time was in here, I'd agree with you, Mr. Dangler. But the name of the charges aren't in here. The only thing that I see is irrelevant is where it states there are mitigating circumstances and parties agree to mitigate and the amount of mitigation. So the fact that there's that statement about mitigation, in my opinion, the jurors are going to say, oh, well, she's less culpable and she's doing 12 to 15, right? And so if she's doing 12 to 15 and she's less culpable than Mr. Gonzales, then he's going to be somewhere between 15 and whatever, right? And so I think that's risky because they're going to do that math, but if they don't know what she pled to and they don't know what she was facing.
Right. I agree with the court that you did face this and you did decide it earlier, but I noticed that when you just read it at the very end, if they look at a charge and figure out how much time there is, there's only one charge here. So the time is here with the charge.
But they don't know what the charge is. It's not in the plea.
Right, but they know it's one charge, so therefore they know the time for that charge. Isn't that what you just read? That they weren't supposed to know the time for each charge? I thought that's what you just read.
That is what I said. But the charge isn't in there. It's just she pled to something.
A count. Doesn't say counts doesn't say the defendant please do a degree felony offense, an optional serious violent offense. It's clear it's one count.
I realize that, but we don't know what the charge is. Just that it was one
You're
charge.
right, they don't. And if you think that comports with your order, I agree with your order.
The name of the charge pled is not in there, nor the amount involved in each particular charge.
Was in this each particular charge you have the amount.
Well, the charge isn't named. I'll allow the exhibit in 371 to be admitted, but I want any word that says anything that says mitigated or mitigation out.
We're fixing that right now, you're okay?
Okay? Let's go into jury instructions.
And Your Honor, do you want me to remark this as an additional exhibit, like 270, or?
Let's make the one I didn't admit that I want to change is we'll make that 371A. That won't go in, and I'll give that to the court monitor right now. And then 371 will be the one that has mitigated out.
Understood, thank you.
All right, so as far as jury instructions go, who wants to start? Dave?
Yes, Your Honor. The mic wasn't on.
Thank you.
So, Your Honor, we've submitted some modifications to our proposed jury instructions. It looks like the parties are mostly in agreement. We differ on a couple of things. In terms of the child abuse instruction, the defense wants an instruction only on permitting, and that is the first request of defense instruction. We've already litigated this, and Your Honor said that it's appropriate to have the alternative of causing or permitting. So we have submitted two different instructions. The first with cause, the second as an alternative to count one with permitting. In terms of the language of element number 1 in the child abuse instruction, we have proposed that element number 1 read, the defendant put Victoria Martens in the care of his violent and or paranoid cousin while his cousin was under the influence of methamphetamine. The defense proposed Fabian Gonzales left Victoria Martens at the apartment knowing that someone was looking for Fabian Gonzales to inflict bodily harm, or knowing that Jessica Kelly was violent and had been recently using methamphetamine. So that second part is very similar to what we have. The first part, knowing that someone was looking for Fabian Gonzales to inflict bodily harm, we certainly introduced evidence suggesting that, Your Honor, and that corroborates Jessica Kelly's story. But that is not a factual scenario that we are willing to undertake for proof beyond a reasonable doubt. Who was there, why they were there, as I said in opening statement, that's not the focus of this case. The focus of this case is the defendant leaving Victoria Martens in the care of someone who was not an appropriate caregiver, someone who either could not protect Victoria or did harm to Victoria. And so our proposed language more appropriately fits the facts of the case. I think that's the only difference. Those are the only two differences for the child abuse instruction. The defense has also requested a lesser included instruction on child abuse not resulting in death. At first blush, the state was going to oppose that because Victoria is obviously deceased. But because causation is essentially the main disputed issue in this case, there is a view of the evidence under which the defendant, reasonable juror, could find, viewing the evidence in the light most favorable to the defense, that the defendant was not the cause of death. And so, under State v. Meters, the state believes the defendant is entitled to that instruction as they requested. So we will not oppose that instruction, Your Honor.
Do either one of you have the instructions printed out? I wasn't anticipating to talk about this today, and so it's hard for me to compare and contrast on my computer. I can only open one at a time. So if someone has a set, and then I can have your set on the computer, just to the one disputed.
We can print them, Your Honor. I just have them open digitally as well. But we can print them.
All right, so the step down will be permitted. We'll just need that step down instruction. I don't know if that's in here.
It's submitted as
Yeah, there it is.
instruction number 5 on the defendant's trustee 14-612.
And does that comport with the Lewis case? I haven't compared it with the Lewis case, the changes in the step down instructions. Did anyone check that?
I have not checked that yet. I'll check that before we do a clean copy. Let me just email this real quick, Your Honor, and we can print it.
The defense also submitted a 145028 evidence of other wrongs or offenses. That's on number 7.
We have not discussed that one, Your Honor. I apologize.
All right, I'm pulling it up right now.
I'm not sure how that relates to the evidence in this case, Your Honor. I don't think that information was introduced for purposes of motive.
Well, there was a reference to it with Jessica Kelly's testimony about at the Downs. And then that there was the marijuana on the nightstand, I believe.
I think the state's only issue, Your Honor, is that it says they can use that for the purpose of determining a motive for the commission of the crimes charged. So the marijuana and the attempted auto burglary would not be motives for recklessly leaving Victoria in the care of Jessica Kelly.
I haven't seen that instruction before, so I'm going to pull it up and see what the use notes say once law would open. So, just give me a minute.
Limiting instruction, I think, is appropriate. I don't think that's the appropriate language.
So it was during Jessica Kelly's examination that came up, correct?
Yes, Your Honor. Yes, Your Honor. I think it was unelicited testimony.
It was what?
Unelicited?
That's what I remember too. At least what they were doing at the Downs.
Correct. I think the state would have no problem with an instruction to read that they are not to consider that for any purpose, for the auto burglary.
What about the marijuana?
And I think based on the court's rulings, the drug use on the day of is relevant. It's relevant to the environment that he placed Victoria in. I think we could say that that is not to be used, or shall not be considered, some sort of character type limiting instruction. So I haven't come across this instruction before either.
I mean, it's basically a 404B instruction.
Right. Right. So there was a stipulation by the parties that drugs on the day of were relevant to that environment.
I'm not sure if it's probably that's probably there. All right, so what do you think the defense, as far as just making it a straight up limiting instruction, that there was this testimony about the alleged auto burglary or attempt to commit auto burglary, and that that's not to enter into your deliberations in any manner?
Well, one would ask why it was introduced in the first place. One of the problems is we never did get a 404B notice, which is required. And part of the requirement is that the state identify what is the purpose of this information.
I don't think, from my recollection, I was going to double check my notes on it, I don't think they asked about that. It was Jessica Kelly just offered it up, and I think we were all a little surprised by that, and we sort of moved on, but I can look at my notes on that.
Well,
I agree, it should not have come in, and it just sort of came out when she was talking about going to the Downs. So now we're just trying to figure out how to deal with it. So.
I believe it was inadvertent, from my memory.
Go ahead. Sure, and go ahead, Mr. Aaron, you can finish your argument.
Yeah, I think we need to deal with those two. I suppose if we split them up and said you're not to consider that at all, and then as to the marijuana, we still need a purpose under 404B as to why the marijuana is going to be allowed.
So my recollection, and correct me if I'm wrong, is that the marijuana was on the nightstand.
That's correct.
And I don't remember what witness that came through.
Well, it came through the criminologist for sure.
That's correct, Your Honor, Detective Pisano. Also, they were on a trip to get marijuana from his brother Steve's from 6:30 to 7 o'clock, and then they left. According to Jessica Kelly, they went to Joseph's house to get methamphetamine. That was from 7:05 p.m. until 7:45 p.m. So,
Right, that was all the day of.
correct, Your Honor. And so that would be the reason for their trips. Essentially, that's the reason they left Victoria in Jessica Kelly's care, was to go get drugs.
Well, that's why we thought motive to leave. It's our position that he did get marijuana, but not methamphetamine, and never said that's what he's going to do, but that's for the jury. How about limiting that you're not to consider it as bad character evidence or something? Because that's the danger that we're trying to avoid.
Right. So this takes us back a couple of years, back when Judge Brown was hearing a case when he allowed drug use to data, right?
Correct.
So that was sort of having to think way back then as to what his rationale was as to why that was relevant. Drug use the day of the commission of the crime. Do we remember, or should I go back to that order as to why he found that to be a relevant consideration?
Well, to some extent, we didn't oppose it because it's our position he went to get marijuana and not to smoke meth or whatever, that it was a more benign and less dangerous situation.
And our reason for introducing drug use was not related to the marijuana. It was for the methamphetamine because the defendant was smoking methamphetamine with Jessica Kelly, was aware of her paranoia, was aware that she was high, and knew the type of person he was leaving Victoria in the care of. And so that was the basis for our proffer of that evidence with Judge Brown.
And so Judge Brown found it to be a misflood or 404B. Did he say why? I mean, we can go back and look at that order.
I don't remember a purpose being.
Because this was one of the issues that went up on appeal, correct?
Yes, it is, Your Honor. It is, and I believe it was knowledge, if I recall, but I don't.
We might have to look into that a little bit more.
Because the mens rea for the child abuse is creating a substantial and unjustifiable risk of harm to the child, and so it's his awareness of the risk.
Judge, as I remember it, the argument was simply that the jury's entitled to assess the credibility of the witnesses at the time, and drugs affect witnesses, so therefore they would be entitled to know what people were smoking and were using, because it would affect the credibility of their testimony. That's what I thought it was when the judge made that ruling rather quickly.
And I think what we're getting caught up in, and that's why I think 1450-28 may not be the right instruction, because this is, so he's not charged with possession of methamphetamine or possession of marijuana, but this jury instruction contemplates a new crime, admission of another crime, right? So he was never arrested for possession of meth, possession of marijuana. So I don't think 5028 is, and that's why it's not fitting, because there wasn't another crime here. He left allegedly to go get meth or marijuana, right? And that in and of itself is not a crime.
Well, prior bad acts don't need to be crimes.
Well, I'm just reading the use note here. It says, upon request, this instruction shall be given at the time of the evidence of the other crime. And so I think we need a limiting instruction. I just don't think it's this one, and that's why I think we can't find, that's why it doesn't really fit. So let's see if there's something that fits better.
I suppose one limiting thing from our point of view would be for the purpose of determining the credibility of Jessica Kelly. She says she went to get a different drug and that it's hidden to this day. And
well, I think I found the rule. I think I found the instruction. It's 1450-22, so it's in the same block of instructions. And here it says, you may consider whether the defendant was, and this is one option, was convicted of the crime of, insert, or committed the act of, insert that, and that's where we put in attempting to buy marijuana, attempting to buy methamphetamine, for the purpose of determining whether the defendant told the truth.
well, the problem with that is what if the defendant doesn't testify?
Let's see.
And I guess we could cross that bridge then, because we haven't decided.
Okay. Yeah. Let's keep looking then.
And Judge, I do have our 404B notice here. It's a sealed document though, so I don't want to read it into the record.
Okay.
24-8.
Essentially though, it is consistent with what I've said in terms of it shows the defendant's awareness. So his knowledge of Jessica Kelly being on meth, by himself doing that with her, and seeing the effects it had on her, he was aware of the risk of placing Victoria in Jessica Kelly's care.
Right, and I understand that, like, that makes sense, but the actual act of leaving the house to go get meth or marijuana, that bad act. And I understand what you're saying, that that created the environment, but how do we make that fit within 404B? And that's why I don't think it is 404B. I mean, that's actually that is this offense, right? The offense he's charged with here, which is leaving Victoria alone with Jessica Kelly, knowing all that, so it fits there. I don't know if I'm being really clear. But there's not really a crime by leaving and going to get meth and marijuana that would fit within 404B with the exceptions, and that's why I don't think that's the right instruction. It's got to be something else. Like, I think I understand what you're getting at, and that's what you got to prove to the jury to convict him of count one.
Correct.
You knew this environment was created, and you shouldn't have left her.
And I think we did refer to motive as well. And I don't know if motive is the right word, Your Honor, but I think because it has to be an unjustifiable risk, the reason he left her in left her in Jessica's care is relevant. And so if they had to go to the hospital and they left her in Jessica's care, that's a different situation than if they're making a drug run. So,
but we do want to instruct the jury that
not to use it for improper purposes, and the state agrees, Your Honor. So perhaps it could be, as Mr. Aaron suggested, not to show only for the circumstances surrounding the environment of the apartment, and not for the character of the defendant or something to that effect.
I mean, so we'd be making up an instruction versus using a jury instruction that's already been written. And I'm fine with that. I just want to make sure we don't have one that would actually fit.
I think part of the problem, Judge, is that it's hard to fit his obtaining marijuana and all the evidence we got today that the uncle had syringes and things, but it seems like propensity, and I think 404 requires us to know what is its purpose so the jury knows. And the state, I thought, said it was his motive for leaving the house or something, but I don't have the appellate stuff in front of me. Actually, yeah. Well, maybe we should go back to that and cover the forest today and come back to that issue.
Yeah, that one's tough. I think we might need to take the night to think that one over.
I agree.
Okay, so
Judge, the other big question I think for the court to decide is on the elements. It's my position that double jeopardy precludes the state from presenting an alternative count that has been dismissed with prejudice by them in 2018. They're resurrecting it without another grand jury, and the defendant has a constitutional right to that. You can't simply, they have been shrinking the counts. This arguably was, more than arguably, they had count one and alternative count one charged in the original grand jury indictment, and then they amended it by agreement of the parties twice to make it less and less. We were down to one count, and now we're charging two again. My impression of the courts, and it wasn't a ruling, but where you were leaning in December, was that you would allow the count to say caused or permitted and require the parent, guardian, or custodian to be an element. That seemed to be where we were headed, but now I'm concerned that we'll have a count plus a lesser and an alternative plus a lesser, when, as the defense's position, is that you cannot cause child abuse by putting her in the care of another.
So are you talking about states that submitted jury instruction 14622?
Yes, both 622 and 623 is, it seems to me the state can present one count. We can argue over the elements a bit. And to have two counts when the state dismissed all of the alternatives in 2018 violates the defendant's right to grand jury and double jeopardy that once it's dismissed you can't resurrect it. The other problem with these two instructions is that they're just saying that Jessica was violent when there has to be knowledge by the defendant that she was violent. Otherwise, her past violence, if there is any, isn't sufficient. Another concern I have with the elements is that we're getting all of this evidence that another man did it, and that indeed is this ultimately this current expert's opinion. And the state is saying, well, we don't really think we can prove that. So then the question becomes, well, why did we go into that for 2 weeks? And how is the jury supposed to consider that evidence if it's not part of the elements? And so we would suggest our language. It looks, I agree, the second half of the language is pretty close, and there isn't a great problem there, but leaving out the unknown man means that a huge chunk of this trial, there's no instruction on how to apply that to the case. We were told in the statement of facts and arguments that the defendant knew that the person was coming and that he was absenting himself because of his knowledge, and that therefore, and the man, I mean, the whole reason the court allowed the hearsay of the man was because it explained why the defendant did what he did. And now the state is saying, well, we don't really know if there is a man or not. I think this is very confusing to the jury. And the only other thing is that on the permitted instruction, which I'll call number 2, it's the 622, they dropped out some of the language on their element 4. It's supposed to say parent, guardian, or custodian of the child, or had accepted. It doesn't allow you to cut that out. And I forgot the Latin term, sui generis, where you have this list, even though the one applies the best, but it gives the jury sort of a notion of what the law means when it says you accept responsibility. So we would ask that we track the language. We think about the unknown man, and the court decides what are we going to do about caused or permitted. Our initial position is cause shouldn't even be charged. If the court is allowing cause, there it is. If the court is allowing caused or permitted, it seems like it should be one count with one verdict form, a lesser and then not guilty as to the one count that still exists. That's all I have.
So I'll let you respond more fully in the last couple of minutes we have, but I am curious, because I hadn't looked at these jury instructions the state submitted until just now. Why we spent a good chunk of the afternoon talking about the gang stuff, potentially the gang stuff, and the drugs, and all that and the fighting and the text messages and the Facebook posts and all that time we devoted when the state was no longer intending to pursue this unknown third person.
And Your Honor, let me be clear, that's not the case at all.
It's not in the jury instruction, though.
It is, Your Honor. It's contained in that same language. So that language is meant to capture the two alternatives that we've discussed before, which one alternative is Jessica Kelly did all of this. The other alternative is that the jury can accept Jessica Kelly's testimony and the DNA evidence that shows that another man was in the apartment.
Where is that in this instruction? Which one?
Because it's leaving Victoria in the care of Jessica Kelly. So either she inflicted harm on Victoria by herself or with another man, or she was not capable of taking care of Victoria and protecting her from this other man. So that's captured by that language, Your Honor. And we can separate those out if Your Honor likes, but the jury is not required to find beyond a reasonable doubt the factual theory.
Oh, I understand that, but what my concern is that most of the day we spent talking about this unknown man and the situation that Mr. Gonzales allegedly created with his fight with Amanda, only for propensity evidence. Because I'm not seeing it here.
That's not the case, Your Honor. No. So the state's theory is that this individual walked into this apartment. Now, either Jessica let him in and she knew him, or she's telling the truth that she didn't know him and he asked for favor. Either way, Your Honor, whether Jessica Kelly participated with this man in killing Victoria or whether she stepped out on the balcony, as she said, and smoked a cigarette, she was not an appropriate caregiver. And that's why we have the language in the instruction as it is. And that's what we have to prove, is that this defendant knew that Jessica Kelly was not an appropriate caregiver for Victoria. And because he left her in her care, that caused Victoria's death.
Oh, I get that.
Yes, Your Honor. And so we're not backing away from the idea that there was a fourth person. The DNA supports the DNA evidence supports that there was a fourth person there. What we're saying is that the defendant's specific language as to that individual's motive, which is that he was there to do bodily harm to Fabian Gonzales, that's something we're not prepared to prove beyond a reasonable doubt. We don't know what that individual's motive was. We don't know what his relationship was to Jessica Kelly or to the defendant. But he was there. The DNA evidence supports that. And so we're not suggesting that we're backing away from that or that we're using evidence for propensity
No, I
at all.
understand that, but all along, my understanding of the way this case was going to be presented, which is why I made the evidentiary rulings I did along the way, is that the state was pursuing two theories. One, the defendant caused the death of Victoria by creating a situation at the barbecue with Amanda that he knew was going to result in a violent either retaliation or fight, and then he left Victoria at the apartment with someone who couldn't take care of her. Or, option two, the defendant was reckless in the sense that he permitted Victoria to be in an apartment with Jessica Kelly, who he knew was in no state of mind to be able to take care of her, and therefore, she killed her. So these two different theories. So all along, I've been operating under the assumption that the state was going to go forward with both alternatives. That's what we argued during, I believe it was the Fulton-Font motion back in December. And so I feel a little bit, not a little bit, I feel a lot, frankly, tricked here. Because this is not, I would have not made the rulings I made if I thought, and I understand how you're trying to shoehorn it in here, Mr. Grayson, but this is not the understanding I had about how the state was going to present their evidence on this unknown DNA profile. And again, the only reason I made the evidentiary rulings I did along the way was because that was what was represented to me in December.
And Your Honor, I apologize if Your Honor if I have not been clear, because
Well, this jury instruction
that is
does not have any inference to what you're talking
And
about.
we can clarify that, Your Honor. This jury instruction was meant to capture both of those alternatives, with one being said in one way. So we're trying to use one phrase to capture both alternatives. We can separate those out, but we're not like I said before, we're not backing away from that theory. That is one of the alternatives we mean to present to the jury in closing argument. So we are not backing away from that at all. What we were trying to do was craft language that would capture both alternatives with one phrase.
It's 5 o'clock. I'm going to need you to rewrite that instruction.
Yes, Your Honor.
Look at the other instruction as far as the prior bad acts. Do we want to do the transport order today for her to be here on Wednesday?
It looks like, should we tell all of our people to come on Wednesday morning?
Yes, please. So I'll get this signed for her to be here on Wednesday. And I know that there was an issue with jury or with exhibits. So I just want to make sure we're clear. The big chart is 14, right? The big chart is 14 of the diagram of the apartment. Because you had changed it from 243 to 14 or 14 to 243. Do you guys remember?
14 or?
So the diagram should be 243. The big one is 243. The small one is 243.1.
Yes.
Judge, can I suggest one thing to the court and to the DA before we reconvene on this mess?
Yes.
Which is that everybody could pay attention to State versus Leal. It's a Supreme Court case by Judge Mensner. It's cited in the case notes for this caused or permitted, whether you can give caused or permitted as an instruction.
Right, I have all that.
And I think Leal explains the issues better than I ever could. So if everybody reads that, we might be in better shape. I don't know.
And Your Honor, we've discussed Leal before. The other case that is important to this is Nichols.
All right, we'll take a look at it. We'll have that at work tomorrow. Thank you.
Thank you, Judge. That's all I wanted.
All right, thank you.